Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Oh, good morning, good afternoon, good evening, good night, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, and however good it feels and why you're doing it in the first place, I don't care. I'm just glad you're doing it here with me. And Yoda is in the middle of his daily 5-minute struggle session, so all the dog noises are attributed to Yoda for the next few minutes. We are here to bring you the reaction, the commentary on the most recent Sarah Boone hearing held earlier today, the 14th of September, 2024. And it's a special daytime stream here, so I live here in South Korea. As many, if not most of you know, it's a holiday here. And so I have some free time and I wanted to catch up on this because it's going to be a busy next week. If you want to skip all the fellowship and philosophizing that goes here while we wait for the stream to populate and people to join us, just scroll ahead until you see the little intermission sign pop up. And that's when you know it's time to get into the meat and bones of the thing. But how are we all doing? I'm really, really glad to be doing this here today, just to see what kind of a new audience we get when I'm normally in the office at work. So this should be fun. And for those of you that aren't familiar with what's going on here, it's just a normal old trial-y stream, but because it's unrecorded, we'll be stopping and having a little bit more commentary than we normally would. During normal trials, we tend to try to keep as quiet as possible while people are talking, and super chats and things like that come up. We'll flash them on the screen and then read them during natural breaks, sidebars, morning breaks, afternoon breaks, etc. But because this is not a live hearing, we'll be more free to address super chats and things as they come in. We've got both dogs here basking in the early afternoon sun. So the emotional support pig dog cam, potato pig dog cam is online. At the $100 mark, we unlock that achievement we release the hounds on the emotional support potatopig.cam, and we progressively go up there with our various rewards and punishments as we reach the deal. So please feel free, not required, not requested, but any super chats and donations are generously and warmly and sincerely appreciated and received with all humbleness and humility. Thank you so much for supporting the channel, everybody. And we have our like and subscribe poll set up and ready to go. So as you come in, hit that like button and subscribe. I ask you to subscribe to the channel. Do me that favor. Sign up for all the notifications. Don't miss anything, because we've got so much coming up in the next couple of weeks that it's crazy. We've got Clayton Eckert stuff, we've got Karen Reed stuff, we've got the Sarah Boone stuff, we've got a brand new case that Megan Fox and I will be discussing, likely the better part, if not all, of next week, a very, very interesting case involving some very familiar characters. So stay tuned for that next week. But if you want to make sure your comments get read and addressed, answered, and whatnot, super chats are the best way to go. So that's, because they come up in bright friendly colors and they get automatically starred, so that will guarantee it gets read. So thank you very, very much for being here with me. Our like and subscribe poll today, again, as you come in and do the like and subscribe, all the YouTube stuff. Today's like and subscribe poll is: should the media be allowed at Sarah's evidentiary hearing? This is what we're going to be doing today. I understand this is going to be the main thing that the judge wants to address today, is the issue of whether or not the media should be allowed at Sarah Boone's evidentiary hearing that's upcoming. So that's what the like and subscribe poll today is. Should media be allowed at Sarah's evidentiary hearing? Of course, it's a public hearing. Yes, because we want to see. Yeah, no, maybe, I don't know. And no, it's too prejudicial to her. I'm going with number one. Of course, it's a public hearing. The public has a right to attend. The media has a right to attend. We'll talk about it as we go along. All right, I think that's kind of it. That's really all we have to get out of the way here first before we jump into it. This is kind of a longer hearing. Her hearings are normally fairly short. The one, the previous hearing, which we actually reviewed last night, was about an hour and 15 minutes, hour and 20 minutes, something like that. This is nearly a 2-hour hearing, so settle in. And oh, by the way, I will be kind of popping on and off camera for a bit because timing didn't work out. It's now 12:42 p.m. here. I thought I'd have enough time to eat this delicious baked chicken I was making, but I ran out of time. And I in principle don't like eating on stream or watching others eating on stream. So when I cut the camera off, that's just because I'm taking a bite of succulent KFC's baked chicken. It used to be fried, but I baked it. Right. That's it. Kat in Virginia kicking us off, putting us on our initial step towards unleashing the emotional support. potatopig.cam. Kat in Virginia with the super sticker, the cat. Thank you very, very much for that. All right, let's do the intermission thing and get on with it, shall we? I see no reason to delay any further. Yep, I guess we're good to go. Hang tight. We'll see you in just a few seconds. About 20 something, I think.
This is a brief intermission.
You're very much appreciated for saying that I'm appreciated. I appreciate that.
This is a brief intermission.
Thank you very, very much. I'm going to have a search and/or seizure. More likely the seizure. I appreciate you.
This is a brief intermission.
I appreciate you. All right, welcome. Welcome to the Sarah Boone hearing on whether the media should be allowed at her upcoming evidentiary hearing. His hearing was September 14th, which is today if you're watching me now. September 14th, 2024. One of the last few hearings is scheduled before her October 7th trial is scheduled to get underway. So we are going to go through, we're going to react, we're going to comment on the hearing that was held earlier today. The main issue is whether or not media should be allowed to participate, whether they should be allowed to attend and stream or broadcast, whatever, her hearing while she reviews and comments on the digital evidence that's been presented in the case and other matters.
we're gonna have to see how the judge was out. She is representing herself, and by and large, she is doing a fairly good job. As I said previously, she's doing a good entry level law student level of competency. She's burned through 8 different lawyers for one reason or another, and she has been left representing herself and not doing too poorly. She does surprisingly well in some areas. And let me turn down my fan here. She does surprisingly well in some areas, and she comes really, really close to doing spectacular in other areas. And in other areas, she just leaves you baffled. For example, in her last hearing, she was doing a spectacular job of making one of the courtroom guys, the bailiffs, I guess that's what they're called, me law talking guy, making one of the bailiffs sound kind of like an idiot, but she just missed sealing the deal. Not one of the court bailiffs, one of the prison people, one of the jail guards, sheriffs, one of the jail sheriffs, but she just stopped just short. And then out of the blue, she tells the judge, she says to the judge, I'm sorry, this might be a lame question, but what does sustained mean? And she's like, brr, brr, brr. How can you go from actually delivering a very good cross-examination to a sheriff, and then the next thing out of your mouth is, what does sustained mean? She is a true gem. I said, she does quite well. I'm actually genuinely surprised. And for those of you that watched the Darrell Brooks trial, he was just insane. He was just batshit crazy. That trial was amusing just because he literally had no idea what he was doing, and he would just make an idiot of himself. Her, on the other hand, her trial is going to be fairly interesting. It's going to be entertaining for other reasons. Unlike Brooks, who was a complete mess, she is just good enough to be interesting. So it'll be entertaining for a different reason. Trust me. Okay. Well, let's see. She has a YouTube helper. She ain't that bright. Well, see, that's the thing. She's not stupid, but she's not as smart as she thinks she is, which is kind of amusing. It comes together in quite a nice little way. But all right, without further ado, as they say in France, or so I'm told, let's bring this on up. Now, at the previous hearing, the very last hearing, she made and won several motions. Good for her. She's batting about 70-80% success on her motions. So she's not a complete moron, but she ain't as smart as she thinks she is. Now, her last motion was whether or not she should be allowed to be unhandcuffed and unshackled in the courtroom. She won that motion, and basically the results were that pre-trial, she will have her handcuffs removed, her the chain around her waist removed, but she will remain in leg shackles. But when trial comes, when the trial starts, her handcuffs will be removed, the waist chain will be removed, her shackles will be removed, but she will be placed in stun cuffs around her ankles, so that if she gets out of line, goes crazy, tries to stuff someone else in a suitcase, they'll just go and nail her with this shock collar, with the shock ankle bracelets, I guess. So she won that. So she's still in cuffs and chains. So I assume what we're seeing here is the big old bailiff getting ready to release her from her bondage. We got one more starred thing coming in. This one, True Crime Utah says, I want some chicken, but my car key is lost and I'm stuck at home. Oh, that's the great thing about living in Korea. Everybody delivers. It's not just like they have called Coupang Eats. It's kind of like Uber Eats, but like KFC has their own delivery service. Burger King has their own delivery service. McDonald's has their own delivery service. Every restaurant has their own delivery service. It's great. All right, let's get into this. Let's get after it. All right. Yep, they are releasing. They're releasing the chains that bind. Release the Kraken. Hey, Flux. What? She's being released. Why is she looking so angry? Tammy Fayad. I want the remote control for the stun cuffs. Saucy. Thank you, Tammy, for the $2 super chat. How about some audio, people? Now this, all right, I'm going to fast forward here. Just
to you via U.S. mail.
I just wanted to make sure the audio wasn't my problem. It's not. Prosecutors swearing her in. Now, see, she's being sworn in. Although she's representing herself, she's being sworn in because if she has a lawyer, her lawyer speaks on her behalf. And anything her lawyer says in the course of representing her can't be used against her. That's why it's always good to have your lawyer speak for you. Have your lawyer answer all your questions. Don't speak for your lawyer. Let your lawyer speak for you. Don't make objections if your counsel isn't making the objections. Don't explain things your lawyer doesn't explain, because ultimately your lawyer's comments can't be used against you. But where here she is representing herself, she's also the defendant. So what she says on her own behalf can be used against her. So that's why they're swearing her in. And it's a tricky position to be in. So that's why they're swearing her in, although she's acting as her lawyer today. All right, Judge, turn up the volume. Pump up the volume. Pump up the volume. She always looks angry. She does. I guess that. Yeah. All right. I wonder how long it takes. All right, we're just going to fast forward till I hear some audio. Really?
The certificate of service reflects the 13th, but
TV on the Orlando Sentinel?
yes, ma'am. So there was a motion to intervene for the limited purposes of opposing closure that was filed on August 12th by WFTV. It was sent to you by U.S. mail at the.
All right, we've got to find the exact minute. All right, there we go. Now the judge is way overmodulated. turn down the judge's mic just a bit,
so it doesn't sound like he's just eating his microphone.
But all right, what we've got here, we have the media that are making these motions to be allowed to show and stream, and her upcoming evidentiary hearing, where she in court is going to review very important pieces of evidence. In other words, we want to see it when it happens, and that's what the media is doing here, and she's going to argue against it.
To address the factors under the case. So my intention for this afternoon is to have Ms. Boone proceed first with anything that she'd like to tell me. I will hear from the state if they have any position on the matter, and then I'll hear from you, and then the court may be in a position to make a ruling at that time. Okay? Yes, ma'am.
Ooh, we have a very important question coming in from IDK James for the $20 super chat. You definitely get a bell chime for that. Does it not leave grounds for appeal? As I said, I was a JD, but pilot now. She has made it very clear she wants representation. He hasn't said she can't get reputation. He hasn't said she can't have representation. He's just said you can't have free representation. You've had 8 appointed lawyers, well, 7 appointed lawyers, and at least one was paid for like a day. But by and large, almost all of the 8 lawyers she's had were free public defenders that were appointed to her. She had problems with each and every one of them. He just said, you have the right to have a lawyer. We've appointed 7 or 8 of them for you. You have problems with all of them. You can't just pick and choose and delay and delay and delay. So if she wants a lawyer, all she's got to do is pay for one. He just said, you've burned through your available public defenders. And I mean, I've heard of people getting maybe there is a genuine problem with your public defender and they'll give you another one. and maybe 3, but I've never heard of anyone who's burned through 8 lawyers and gets a 9. I've never heard of anyone who's burned through 8 lawyers on a single case. So they're not denying her right to representation. They're just saying you don't get a freebie, and we gave you all the freebies you're going to get. I'll be curious what the higher courts say. Plus, I'd imagine there will be a pretrial stay. No, I don't think so. One, she hasn't asked for one. She complains that she's unprepared, but she hasn't said, I need a continuance, or may I please have a continuance. So, and the judges, I think he's going to go through with it. She's had 5 years to prepare. She's just been futzing around, getting rid of lawyers and having problems and being problematic. I think this is going to go through on October 7th. So let's see what happens. But thank you very, very much, James. Appreciate it.
Seat back there.
Or wherever you feel most comfortable.
I can just sit back there while
Okay, thank you.
until you're ready here.
Thank you, ma'am. All right, Ms. Boone, you can proceed, ma'am.
First and foremost, I do not know what it is that you are referring to.
When you say you do not know what I'm referring to, what do you mean?
Motions were filed by the WFTB and the Orlando Sentinel.
Yes, ma'am. So there was a motion to intervene for the limited purposes of opposing closure that was filed on August 12th by WFTB. It was sent to you by U.S. mail at the correct inmate legal mail address on August the 12th. And the Orlando Sentinel's motion to intervene and notice of joinder was filed on August 13th. And it reflects, it said the certificate of service was August 13th, and it was sent to you at the same legal mail correspondence address at the Orange County Jail. Have you received either of those motions?
I have not.
Okay, I have copies. Oh, perfect. All right.
And I do apologize on the Sentinel one, but the portal was down for a little while, so I love the attempted to file it yesterday because it actually got filed.
That's why I'm saying it. The certificate of service reflects the 13th, but the filing information is of this morning. All right, Ms. Fugate has, I am pronouncing your name correctly, am I not?
Yes,
Thank you. Ms. Fugate has provided copies of those motions. So Ms. Boone, if you'd like to take a look at those, feel free to take your time to review them. And then after you've reviewed them, I may have the opportunity to answer any questions you have about them if I can, and then we can proceed.
So, I mean, this has been a constant complaint for her. It takes a while. It takes too long, she's saying, for me to get copies of motions and things.
If you want to provide those to Ms. Boone as well, you can do so. Thank you. State, do you need a copy of them?
So everybody's got copies to give her. She's got copies. I got coffee. Which sounds the same in Korean, by the way. Copy and copy. There's copy and copy. Oh, while she's scribbling down there, IDK James again with another $10. Thank you very much, brother. Appreciate that. This is pretty unprecedented, though. I only practiced in the UCMJ. She did ask for a continuance because she was pro se and needed time to prepare. See, this is where we get a little bit technical. She just said, I don't have time. Or I didn't receive my discovery was a month late. I'm not prepared. She's said these statements. She hasn't filed a motion asking for a continuance. She hasn't even asked for more time. She's just said she doesn't have enough time. At least if she has actually formally asked for a continuance, I haven't seen it. She hasn't said the words. And he's treating her like any other pro se litigant. She is expected to have the same basic understanding of court rules and procedures as a reasonably competent attorney. She clearly doesn't, but that's what happens when you represent yourself. You're held to this, you as a non-lawyer are held to the same standard as a reasonably competent lawyer. That's why you're an idiot if you represent yourself. She should have been nice. She should have been nice, but she wasn't. So that's the rub here. She hasn't specifically, as far as I'm aware, asked for a continuance. I could be wrong, but I haven't seen it. All right, she's reading through the motion from the TV people to be in the courtroom. What do we got going over here on the computer screen down here in the bottom left? It's playing Tetris. What's going on down there? Can't see. She did ask, denied. Yeah, I didn't see it. I haven't seen it. I don't know when she was asked. See, I remember, this is how I remember it. And I'd have to go back and see. I could be completely wrong, but I just remember her saying, don't have my discovery and I don't have enough time to prepare. And he just said, hey, the dates are the dates. Or she said, I can't be ready by that date. Or she said something. That's how I remember it. I'll have to go back. That was the hearing where she was told she ain't getting lawyer number 9.
If I may say.
I'll have to double check that.
Yes, ma'am.
One of my topics of discussion, as you know, are the requests in regards to
See, that's how I remember it. I could
and
be
internet
wrong.
being one of the most important. Would I have had access to that? I
Oh,
would
yes,
have
okay,
had
so
this
she-
and not had to sit here unprepared.
So she has repeatedly in a written motion and then in the previous hearing said, I need internet. I need to be a special flower. I need the internet to do my work. I need a designated phone line. I can't use the common jail people's phones. I need these special internet connections. I need the special phone service so I can prepare for my trial. And he's like, yeah, not my problem. That's the jail's problem. And she's complaining about it again. If I would have had the internet, if I would have had a phone, I could have been prepared, but I'm not prepared.
I believe that is a major violation to my due process of me not having these in advance to prepare properly and to utilize the court's time and everyone else's here by me having to do this now. So I wanted to put that out to you that I am unprepared for this. I did not know that I had a statement to prepare, as everyone else did also prior to being here.
Ma'am, you were provided the case law as you had requested at our last hearing.
Mm-hmm.
It was mailed to you. You asked for the case law that the court was making reference to. You specifically asked for it. That was provided to you. It was mailed to you.
Case law?
Yes, ma'am.
Yep.
What was the date that it was mailed?
August 9.
See, the judge is not putting up with anybody's BS. And he's not being mean. He's not getting angry. He's calm, cool, and collected with both sides. He holds both sides to account. He doesn't let anyone play him. And she's getting befuddled because he calls her out on her bluffs. I didn't get this. Well, yeah, you did because I sent it. But I did on August 8th. He's just answering her questions calmly and rationally and reasonably. And if she says something, well, he'll ask her, well, when? Her big deal at the last hearing was almost all of my, the majority of my files, I can't access them. And he's okay, which ones? A lot of them. Okay, which ones? Files. And then she was talking about something else. And she said, well, I opened this one, then I checked this one. And it turned out she said, well, I checked like 8 or 9 of them. And then I went on somewhere else. She's like, all right, there you go. And then she later says that by and large, she can open all the files. And he's like, okay, so which ones can't you open? And I just love that he doesn't let her get away with making these generalizations. He wants specifics, and she asks for specifics. He gives her the specifics.
What was provided to you on August 9 was the additional copy of the pro se packet as provided by the Justice Administrative Commission. You were provided a hard copy of that in court, along with the case law that was referenced at the August 9 hearing that the court had said that it had reviewed in anticipation of the hearing that we were having this afternoon.
I don't have that. The only thing that I was provided was the notice of provision of witness list from the state, and then the JAC packet.
Those were both provided to you in court. You are correct. The balance of the things that I'm speaking about were mailed to you at the legal mail address on August 9.
Which I have yet to see.
Okay.
They need her like a receipt, a service receipt.
Ma'am, with regard
So
to,
they can go, you received it on this day.
This is the first time I'm seeing each one of these documents.
I understand that. They were filed August 12th, and unfortunately this morning due to an issue with the e-portal.
I wouldn't have internet access anyway to receive those.
They were sent to you via US mail as well.
Yesterday?
Yes. So you're not wasting the court's time. You can feel free to review those at this time.
She's also learning that a lot of times motions like this, you don't get weeks in advance to prepare.
Are you referring to? State versus Smith?
I believe that those are the circuit court opinions that are referenced in WFTV's motion, which cite to the Miami Herald versus Lewis decision, which is the controlling law on this matter.
All of these. And these are mine to take. Thank you.
What are you doing, dog? She's reading through this motion. And as I was saying, a lot of times you don't get days or weeks to prepare. Things get submitted a day before hearings, or in this case, 2 days before. It's just reality. She's like, I don't have time to prepare. Neither has anybody else. Siobhan says, chat is funny. I don't want to miss one joke, but this is going to turn into a podcast right now. Chat is awesome. The Vice Squad chat is the best chat on the entire internet, hands down. Sarah, you need to read a little more carefully than that. Don't just thumb through it. I really do like this judge. Fire and Ice says this judge is a saint. I do like this judge. He's very, very fair, very, very even-handed. He has every reason to be just infuriated and frustrated with her. He probably is, but he just doesn't show it. He's like, hey, you got everything everybody else got. You asked for the case law. I gave you the case law. It's not my fault if you didn't read it. She probably can't have access to a secure email. To the jail. Yeah, the jail will watch her email. It's the only thing they can't look at is privileged communication with her lawyer. But guess what? She ain't got one of those. Pro se attorney learning on the fly versus state prosecutors have used the same precedent sites for numerous cases over many years since law school. Yep, that's what she's contending with. This is a lesson If you ever find yourself,
Whatever the court is, there's only so much that I can do just not receiving these.
yeah, well, if you ever find yourself in a situation where a public defender is appointed to you, try to get along with them. Otherwise, you may find yourself in Sarah Boone's situation. Now, you can't give her unfettered email access. You just can't do that. What differentiates her from every other person who's sitting in jail waiting for their hearing? Even if they have lawyers, they still have every right to participate in their defense. They still have every right to use resources. So you can't, if you give it to her, you've got to give it to literally every other inmate in Florida. You can't give her special treatment. That's the situation here. She might think she's a special little flower that needs special little assistance, but you can't just say, okay, you get your own telephone to call your witnesses and do all things. You get your own designated internet connection so that you can browse the web and you can go do all these things, and you just can't do that. And I don't know, IDK James with the $5. We / officers of the court give latitude to pro se defendants to a point. We want a fair trial, go pro se, but give her the tools. This is unique. This is not unique. I mean, really. I mean, respectfully, someone who's been accused of murder representing themselves is not unique. We saw it with Daryl Brooks. We've seen it with a lot of people. There's been several cases that have been shown on court TV and Law and Crime, where people that have been charged with murders, many much more heinous than this, they represented themselves. They don't get the special internet connection that no other prisoner in the entire Florida correctional system gets. I mean, she's already got a laptop, which is a big deal. She's getting about as special treatment as you could expect.
Have any opportunity to look up any case law of my own in the meantime, so.
You can proceed, ma'am. What is it that you'd like to tell me about your concerns regarding the September 3rd evidence viewing that's been previously scheduled?
My concerns is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court, other than sensationalism and exploitation, the purpose would be for them to watch me look at the remaining bit of my evidence that has not been globalized. Again, my main concern is it is for exploitation purposes, which has already been greatly applied to my case in many ways globally again.
All right, what she should be arguing, of course, I don't expect her to, but what she should be arguing is the jurors have not been chosen. The jurors are still out there. The jurors in my case are still out there watching the news. They're reading the newspaper. They're online, and they're going to be seeing evidence in my case. They're going to be pre-exposed to my evidence, the evidence in my case, which is going to contaminate the potential jury pool, and it would mean that I can't get a fair trial. That's what she should be arguing. It's not going to work, but that's what she should be arguing. She has to overcome the fact that this is a proceeding that is it's a public hearing. It's a public proceeding. The public has a right to be there. The media has a right to be there. He's referring to a case that says that. She has to overcome that. Just saying, it's sensational. That's not enough.
And I see on the motion to intervene for WFTVs, my question is, why is this an important criminal proceeding?
All criminal proceedings are important.
Why do they need to have it monitored? I don't understand the reasons why just for this one. I'm not asking for all of my other hearings to be closed. Simply, this is my one and only It is my right to have some kind of privacy regarding my case. Nonetheless, it is an active case. It is my understanding that some information is not able to be publicized due to privacy. And it's not their right to pry and exaggerate, which is the whole point of why they want to be included in this one and only most important hearing that I would say that I have on the horizon. The press doesn't have a right to press themselves into everything in regards to my active criminal case. And I feel that from this, one meeting should be closed to the press.
Now, she said the media doesn't have the right. I would suspect either the judge is going to ignore it or the judge is going to go, show me the case law that says the media doesn't have the right. Welcome to Susan M., the newest member. Susan M., the newest member of the Clean and Sober crew. Welcome aboard. Hope you're here for a considerable amount of time.
I can rightfully, lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the internet. I'm trying to salvage whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing. And I'm asking
what's
for
the case law
their
to
admittance
support
to
that?
be closed.
Okay.
This is an active, ongoing investigation case.
Anything else, ma'am?
Are you done yet?
No, Your Honor.
State, do you have any position on Ms. Boone's closure motion?
No, Your Honor.
All right. Ms. Fugate?
That was judge talk. For you done yet?
Thank you, Your Honor. I think Ms. Boone's argument really flips the question.
Now she's the media representative for whatever station it was. I can't remember. She's going to set her straight. This is a woman who regularly appears in court. I don't know who she is, but I know this is what she does because she's here. This is a woman who regularly appears in court and argues why the media should be allowed to attend hearings.
It's not why the media wants to be there. What transpires in the courtrooms, even pretrial hearings, is public property, and there's a right to be there.
Mm-hmm.
I'm not going to go over.
Oh, it's almost like I'm smart and know what I'm talking about.
Knows it well, but it's a very strict standard, and it's the plaintiff's burden to meet. I haven't seen a case in Florida where a criminal case was closed on a defendant's privacy concerns. We're not talking about third-party privacy concerns or something that's not inherent in the proceeding. This is the evidence. And even with respect to the evidence and it being an active, still an active case, Florida law is clear that once discovery is provided to the defendant and accessible to the defendant, that becomes public record. That too becomes open to the public. So with respect to the first part of the analysis, I don't think the defendant has established that this hearing needs to be closed to protect her fair trial rights. Publicity isn't necessarily synonymous with prejudice. She has to show widespread, adverse, hostile publicity, and then specifically show why that publicity is going to be aggravated by access to the September 3rd hearing. The discovery in this case has been public. I'm not sure what specifically would be aggravated by access to the hearing. So I don't think she's met that first burden under Lewis. And importantly, the admissibility of evidence, Ms. Boone said she didn't think there was anything suppressible, but even if there was, courts often suppress evidence, but still allow access to the hearings and the evidence themselves. That's fairly routine. That alone, just the potential admissibility, that alone is not a sufficient reason under Lewis to close a hearing. And as Your Honor is aware, there's plenty of alternatives under the second factor to protect the defendant's fair trial rights. You know, careful questioning and jury selection can protect against publicity. The courts of this circuit have had their fair share and are
well. Elsie Merritt raises a good point here. Might she argue the little things about cameras in the courtroom, such as camera angles looking over his shoulder right now? will that be the angle for trial? Compromise her case? This should not be the angle for trial, particularly if she's got a laptop where you can see the screen. But that would make much more sense if she were to argue, like, okay, if the media has to be there, there should be some restrictions. They can't rebroadcast. They should be prevented from rebroadcasting my evidence. They should not have cameras in the courtroom. It shouldn't be streamed. Those arguments would hold a little bit more weight than the media is not allowed here because I said so.
Familiar with high profile cases, and they're well equipped to insulate and protect juries from even prejudicial publicity. And finally, any closure would have to be effective and broader than necessary. Again, I'm not sure why the hearing would need to be closed, but I think even Ms. Boone has indicated it would be ineffective with what's already out there. And that was a consideration under Lewis. If the information is out there, the discovery in this case has been public, there's no reason to close a hearing that's simply going to discuss things that have already been made public. I think heightened public attention only increases the need for transparency. Closure of judicial proceedings is a drastic remedy, and I don't believe the plaintiff has met her burden in this case, Your Honor.
Okay.
Unless you have any other questions.
I do not.
Thank you, Your Honor.
All right. Any closing remarks from you, Ms. Boone?
Yes, Your Honor. First, I'm only asking for this one hearing, which is a very important hearing. I believe that the press is simply in it for ratings and publicity. My evidence is active, and I'm trying to salvage the little bit of anything that I have pertaining to my evidence that is not available online, which would be in that hearing. And I also heard she was speaking in regards to once discovery has been received, that is therefore public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information. I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly. It's publicity. This will incredibly.
Now, if she has access to publicity, why doesn't she have access to anything else? She's. I kind of have to take back what I was saying yesterday. She does pretty well on basic things that are common sense, but when she's clearly in over her head, way big time here. IDA James, thank you so much. I don't think we're in much disagreement here. So what makes it unique is the court's sua sponte ruling of abandoning counsel. Well, the court didn't. I mean, sua sponte is of the court's own authority and power. They didn't rule that she abandoned counsel. Her eighth lawyer asked to be able to withdraw, and the judge said yes. And then she asked for yet another appointed counsel, and he said, "Your behavior indicates you can't work with them. You've run out of public lawyers." So again, it didn't really rule that she abandoned her counsel. Her behavior has waived her right to have another court-appointed attorney, a ninth appointed attorney. I haven't seen, and of course, again, this is not my area of hyper expertise, but I haven't seen any case law that says you have a right to an unlimited number of court appointed attorneys. And that's what the judge is. And judge saying, you've burned through it. You've demonstrated you can't get along with them, and no more court appointed attorneys for you. You can have any lawyer that wants to work for you. If they want to work for you for free, cool. If you want to pay them to work for you, that's cool. But we ain't going to give you another one on the government dime. So I'm curious what the high court say. Hopefully she files. I hope, I mean, if this issue wants to be appealed, I hope somebody else files for her. I hope somebody else files.
Enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received from Australia being the most recent. So I do not believe just because
Ozzy Overlord, you got something to say?
They would like to, again, in my opinion, for ratings and for publicity.
Hayden, are you sending her some
There also is a
letters?
solution that I believe, my understanding was that this could be held at the Orange County Sheriff's Department. The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court. I would like to be able to properly prepare for this. Would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email.
Not having a dead body in a suitcase in your living room floor would have helped a lot too.
But I am unprepared for this rebuttal in regards for me to have privacy, expected privacy to a certain degree, and by law, to have this one hearing closed. And we also have an active case that is ongoing, active evidence, and there's a solution for it to be held at the Orange County Sheriff's Department as well.
Okay. Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but the parties have reached an agreement to do this on our own. And as soon as that gets accomplished, if it's accomplished to both of our satisfaction, then I'll let the court know so you can free up the hearing time.
Okay, we'll address that momentarily. Ms. Fugate, anything else? All right. Under the Miami Herald versus Lewis case, ma'am, Ms. Boone, you had the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied.
Denied.
The court will follow up with a written order that you'll be hand delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon.
She's like, oh, hell no, I'm sticking around for this. Now, okay, that was supposed to be the main issue they were discussing today. What are they going to talk about for the next hour and 20 minutes? This should be interesting. I have no idea what they're going to be talking about. That was supposed to be the big issue.
Mr. J. Yes, ma'am.
Forgive me. When you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
What was it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th. You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not aware of, I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing now, because you asked for it orally. So you orally moved or attentiously moved to have that motion heard. And we set it up for today since we already had the hearing time carved out.
He cannot explain this more basically, Sarah. You asked for it. He said, okay, August 14th, we will have a hearing on whether or not to close the evidentiary hearing. At that instant, you knew there was going to be a hearing on it, and you should prepare to argue your motion. Sarah, you cannot make this more simple. See, and again, I love he's not getting upset. He's just saying, well, you asked for it on this date, and this date, and that's why we're here. He's not giving her an inch that she doesn't deserve.
To address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said, I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
Which I have yet to receive, and I was
He
not
told
instructed
you in
by
court
anyone.
he would have the hearing. The sending it to you by mail is pretty much a formality at this point. He accepted your oral motion at the hearing and scheduled a hearing date, Sarah. Sarah, you're making me look bad here. Sarah, I was telling people you're not doing so poorly so far. You're doing shockingly not terrible. That's what I've been telling people. I praised you yesterday for your pro se abilities. You're letting me down here. You're making me look dumb. Chad, I take back about 85% of the good things I said in the previous stream on Sarah Boone. I've seen the light.
Court that was an oral motion.
Oh, hey, we have closed captions now.
Requesting
Cool.
privacy. I thought it was just a comment that I could have on record.
Ma'am,
I don't need to do anything further.
that's why we set the hearing, because it was something that you had asked for. And that's clear in the order that was provided to you on the 9th as well. It says that we would have a hearing today on the 14th.
And when did I receive this?
Well, that was orally told
my
you
God.
on the 9th. The letter itself was mailed to you on the 9th, but the order itself was read to you during the course of that hearing. Specifically on August 14th, 2024 at 1:30 p.m., a hearing will be held in courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB drug tribe, which contains the state digital evidence. The defendant's August 7th letter to the court, delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. That was all addressed with you, ma'am, on August 9 here in open court.
In the order I have yet to receive.
But it was read to you, ma'am. It was read to you as to what we would be doing today and that we would addressing the issue.
Right, what do you think? What do you think, chat? Sarah Boone is sitting there. The judge says, she goes, I need money. I need money for this is a hypothetical. She tells the judge, I need money to hire a lawyer. The judge says, okay, there's $200,000 that are available to you, and you can walk down to the post office right now and pick up the $250,000. I will mail my order to you. Is she going to sit in jail and then come bitching later that, oh, I didn't get the mail saying that I could go walk free and pick up my $250,000? Is she going to bitch that she didn't get the mail yet? Is she going to bitch that I didn't know you were going to do this? Or is she going to get up from her seat right now and run to the post office? She's not going to wait. So to say, oh, I know I said that I don't want this open, and you said, okay, we'll have a hearing on this, and this will be the date of the hearing. And now she's like, oh, I didn't know this was the date of the hearing because I didn't get the written information. No, she's just being a little, what's the word I'm looking for? Obstructionist, I guess, trying to assert her dominance here in court. It ain't gonna work. He told you. You would instantly jump on something good that he said without waiting for the order. So, I think that waiting is that's not a good argument there. I just think this is James. Thank you so much again. I just think every American deserves a fair trial. Absolutely, that's the fundamental. That's the foundation of our civil and criminal rights. We all have a right to a fair trial. I think she's guilty. I pretty much know she's guilty. Still just hate the sua sponte. What do you think the Court of Appeals will rule? Maybe Fed, not Florida. It's just me talking right out of my keister, but I think an appeal on that issue would be denied because she was not denied a right to counsel. That fundamental right, her right to counsel, has been preserved. There was never an order saying you absolutely cannot have a lawyer represent you. Now, through other cases, we are guaranteed right to a counsel if we can't afford one. One was appointed. 2 was appointed. 3 was appointed. 4, 5, 6, 7, 8 were appointed. I'm only aware of one, her first lawyer, that she paid for. There may have been others, but I believe the other 7 were appointed. And for whatever reason, either she fired them, she got rid of several of them, a couple walked away, and then a few begged the court to please be let go. And at some point, her behavior indicates she can't work with one, doesn't want to work with one. She's being obstructionist. She's being dishonest with the court, and these other reasons is you don't have a right. You had your right to a court-appointed lawyer. You used that right 7 times at least, and now you don't get another one. Go find a lawyer. You have a right to a lawyer. You just get to pay for one. So I think that's how this is going to come down if it's even appealed. She has the right. She exercised her right. She abused the right. She lost the right. She waived the right by her actions. That's I think the judge was 100% correct. But also, James says, right for an appeal, at least based on what I learned at SC. Well, I would, if I was her, I would appeal it. Why not? It doesn't hurt. It certainly doesn't hurt to appeal it. There would be no reason not to appeal it. So that's it is an issue. It would be an interesting appellate issue because it's a fairly interesting situation. And To Be Flair is a new member. Welcome back, To Be Flair. Good to see you. Welcome, welcome, welcome to the Clean and Sober crew. Good to have you back.
Regarding the media's participation, and that's when you asked for the case law. And I said, I will give it to you. Absolutely. And it was all mailed to you on the 9th.
I'm not ever sure of what it is that I'm supposed to be doing with.
Go on, civil.
It's now oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court.
Oh my God.
August 9th.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to.
If
Any
the
reason for Ms. Fugate?
If the judge tells you a hearing is coming up, if the judge tells you, oh, okay, you have a good point, let's have a hearing on it. I'm looking at the law. We'll have a big hearing on it. There's going to be a hearing on it. Be prepared, Sarah. You can't say because I didn't get something in the mail, I couldn't be prepared because he told you in court to be we're having the hearing. Oh, God bless this judge now, man. I would not have let it go on this long. God, now I've got the hiccups, damn it. I'm just going to stop talking and drink some coffee.
To remain state. Okay.
From the state.
All right. Ms. Boone, any reason why counselor for the Orlando Sentinel and WFTV should remain?
No.
Okay. Thank you, ma'am. All right.
I was having,
in addition to,
she said that ridiculous thing. So I had to inhale the chicken and it gave me the hiccups. But patience of Job. This judge is a better man than I am. I would swear. See that I would make the worst judge in the world. I probably wouldn't last very long because I would swear at people, and I can't really hide my agitation. I have this thing where my face just betrays my emotions, even if for like an instant. But if I'm pissed at someone, there's always there's just that flash of my true feelings before I try to mask it. And so I would be the worst judge.
What was set to be addressed today, which was the Ms. Boone's review of the USB jump drive, which contained the state's digital evidence, Ms. Boone's August 7th letter regarding her requests from the Orange County Jail. Mr. J, you made reference to a potential change in the September 3rd meeting. I want to hear about that, sir.
I believe we have reached an alternative solution to an evidence view with the defendant. And as soon as that is accomplished to both parties' satisfaction, then I will notify the JA so that we can release your hearing time.
Okay, that's interesting. Dang it, wrong button.
Can you explain to me?
Yeah, so he's saying we may not need to have this evidence viewing hearing at all, because we're going to try to get together and work this out between us. And if we do, we don't need to have this hearing. That's interesting. Let's hear more.
What the proposed plan is for the viewing.
There will be a time and place where the evidence will be brought, the defendant will be brought, and she will be given as much opportunity to experience an evidence viewing like a defense attorney as possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened so that it can be photographed, inspected, tested, copied as provided by 3220 in the criminal procedure rules. And then the evidence will be brought back to where it's stored, and then the defendant will be brought back to the Orange County.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she agreed to that.
Okay. All right. Ma'am, I don't want to go into specifics of what you've had with your investigator, but has he relayed to you what Mr. J just advised the court of?
Yes, to a certain degree. It has not been fully explained because it is in the process of being spoken about between the two of them. So yes, I do know that that is a solution to my request.
Okay. And did you understand what Mr. J advised the court of today regarding how that process for you viewing the physical evidence would be?
If you could please do so again.
Sure. If you could explain it again for Ms. Boone, Mr. J.
Okay, so finally she's said that she's actually heard something and actually received some information. But some information that I have just received, crazy. 2B Flair, you get the foghorn. 2B Flair has just gifted 10 Legal Vices memberships. Went to I Undermeant What You Stood, BLT, Lindsay, Coffee Flavored Lady, Augusto Pinochet, Pretend Judge, Brianna Burney, Laura Leaney, Muggs, and Leah the Empty Nester. You guys got 10. You got one of the 10 Legal Vices gifted memberships from DB Flair. Make sure you give her a super special thanks. And heads up, there will be a members stream sometime this weekend. A members only stream will happen sometime this weekend. 2B Flair, thank you so very, very much. That means a huge, huge amount to me. Seriously. Deeply, deeply appreciated. And it's also done something. It's done that thing which we love to call release the hounds. We've unleashed the emotional support potato pig dog cam. Thank you very, very much for that, 2B Flair. For those of you who don't know, that is Strawberry, one of my 2 English bulldogs. Yoda is probably in the living room on the sofa under the air conditioner. And so thank you very, very much for that.
Thank you. When the defense attorney wants to do an evidence view, we typically go to where the evidence is stored and then the law enforcement agency. He or she can bring an investigator, and the investigator will take photographs if so requested. We typically don't let the defense attorney manipulate the evidence him or for herself. The CSI, who would be present as well, which is a crime scene investigator from the law enforcement agency, would be the person who manipulates the evidence on the cutting paper. And then you would have the opportunity to review, test, inspect each piece of evidence. So for instance, I'm not saying the evidence, but a piece of clothing, the front, the back, you have the CSI turn it inside out, those sorts of things. And then you document.
Okay, for those of you that can't hear and can't read the noble attempt at closed captioning, she's saying that they would meet somewhere. There'll be a CSI guy there. Sarah won't touch the evidence. The CSI person will open it and manipulate it if she wants it turned over, if she wants a closer look at it. It'll be handled by the CSI, which makes sense because they don't want the defendants destroying evidence. Oh my God, here's the oh shit, too bad, it's been damaged. They don't want that kind of stuff happening. So the CSI person will manipulate and put it back. That's what he's explaining. This is their proposed way of handling this evidence viewing session.
By investigators with photography. Between each piece of evidence, there's a new piece of cutting paper, butcher paper laid down so that there's no contamination for any potential DNA testing. And this is basically how the process goes on for physical evidence. If it gets opened, it'll get resealed by the CSI right there in front of all of us. And the CSI will reseal it with tape, re-put his or her initials over it with the new date. So everybody will be on the same page about why it was open, when it was open, so on.
Thank you for that. If I may, is it closed or is it open to?
No. People that are not involved with the case will not be there.
And if I may, if you know, will my phone physically be there?
If it is stored in physical evidence, then it can be brought over.
She really wants this phone. This is interesting. Every hearing where she has a possible reason to, she mentions wanting her phone. There's a reason she really wants this phone. She keeps asking for her phone records, for copies of the download of her phone. Now she's asking if her phone is physically going to be there. You don't think she's going to make a last ditch effort to try to delete evidence? It can't possibly be it. We got to adjust for dog positioning. There we go. Oh, never mind. Yoda is not in the living room on the sofa under the fan. Yoda is under the table in front of me. Good thing I noticed that. I would have kicked him in the face if I wasn't careful. So yeah, I'm so curious as to why she wants that phone. And IDK James says, to my core, this makes me upset as an officer, but previously also said fascinating appellate issue. It will be a fascinating appellate issue, the attorney issue, if it's appealed. Which makes you upset to your core? Like the whole thing or something in particular? Oh, her requests aren't admissible. Okay. There's a lot that upsets me about this, but the judge is handling it like a trooper.
We're not going to be turning it.
Not a trooper proctor, a real trooper.
Photographed or examined. It can be photographed and physically examined, but in order for it to be turned on, it would have to be done at a different location, where there's something called a Faraday box, room.
Yeah, I know she mentioned wanting her contact list previously. I was just kind of being silly.
Or what? For your phone to be brought over and turned on?
If I can extract any type of information from it.
So, like we discussed in the last hearing, that would be up to you to hire a digital forensic examiner, and then we would make arrangements with that person so that he or she could image the phone in the same manner that it was imaged by one.
Thank you, I'm grateful.
Okay, this is dealing with she wants this as Maddie B was saying, she wants her contact list so she can contact people and try to make arrangements for witnesses and things like that. And she asked for a download. He said, "Well, we can't download it and give it to you. You need to have your own guy do it. You need to have your own forensic analyst do this." And the prosecutor was, I think it was 2 hearings ago, when he mentioned this to her, that she needs to get her own guy, actually gave her a recommendation of someone who does this for defendants quite often. He actually gave her the contact information for a forensics examiner that might be willing to do this for her. Clearly, she hasn't acted on it yet.
Okay. All right. Then, ma'am,
No matter what, we
after
are
having
officers of
Mr.
the
J
court.
explain that
Says-
alternative
says James.
solution to
Although
the
it's
evidence viewing,
so hard
is
to
that
act
something
like
that
it
you
at
would like to
times.
participate in?
Absolutely.
Okay. So then, is it the parties' agreement to no longer have the evidence viewing here in open court on September 3?
That's the state's position, but again, been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the court if you want to free up your hearing time now or wait until we're able to tell you that we're satisfied.
Okay. Ms. Boone, are you in agreement with that alternative solution?
At the Orange County Sheriff's Department?
Wherever the viewing is going to take place. I don't know that a specific location was identified, but yes, where it's going to take place.
I am.
Okay. So then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing as set forth in the August 5 scheduling order and notice of hearing will remain of September 3. If that evidence viewing takes place at a law enforcement agency based on the protocol as identified by Mr. J, I'll just need a notice that's provided, signed by Ms. Boone, signed by the state, signed by Investigator Lane as to when it took place and how long the viewing was. And if that's provided to me, we'll then cancel the September 3rd hearing.
Yes, sir. We'll do that, and we can even list physical items that were brought.
Boo! Boo!
My
They're
only
going to try to resolve
question about that.
They're going to try to resolve it through this this private meeting. Boo! That means if they resolve it, we won't get to see any of it. Boo! But I think that's actually the right way to handle it. Like I said, I do sympathize with her, and I just, regardless of what the case law says, just personally, I don't like the idea of contaminating the jury pool with official court evidence before it's entered into court. But also I wanted to see it. I don't like it, but I want it. Does that make sense? I don't like that the media gets access to the evidence before it's submitted at court, but dang it, I want to see it. We've seen a lot of the body cam footage. Oh, and as the trial gets closer, we will go and review. We've already looked at her body cam footage, I think like 2 years ago, and her interrogation video like 2 years ago. We'll go back and we'll rewatch those as right before the trial happens, so it's fresh in our mind. But I think this is a very, very amicable way of resolving this. It's a very fair way of resolving it. If we can't get this issue solved amongst ourselves, then we'll still have the hearing on September 3rd. Or if there's any other issues related to it that the judge needs to discuss, we can do that on September 3rd. But otherwise, we're going to try to handle it amongst ourselves and you do it privately. I like it, just not happy with it from a content creator point of view.
Is we had sealed at the last hearing the witness list and the exhibit list.
I think all the property receipts and all those sorts of things are already in the public record.
Okay.
I think there's a vast difference between a list of evidence that's already in the public record versus having them look at it with television cameras.
Okay. All right. Fine. Ma'am, are you?
The prosecutor is a little sympathetic to the idea of, possible prejudice from television cameras. Even he's saying, yeah, we're going to try to do this without getting television cameras involved. The prosecutor also seems like a good guy. Like he's doing things like this. He's agreeable to the things that don't really matter to him as a prosecutor. He's actually given the defendant a reference for someone that can download the information from her phone. I like this prosecutor too. I think he seems to be a good, fair guy. He's not stonewalling. He's just not being a jackass for no reason. Good guy, good judge, good prosecutor. I think we're doing good here.
Amenable to that additional procedure that after the evidence viewing takes place, you would sign a notice reflecting.
Catherine says, why can't she have her phone? It's evidence. Yeah, this isn't. She's a defendant in a murder trial, and she filmed him inside the suitcase in her house begging to be let go, and who knows what else is on there. But yeah, her phone is direct evidence of the commission of a murder. So yeah, she ain't getting the phone back. And James again, how are you doing, James? Long time no talk. Well, for ones who say, I'm only admitted to South Carolina military and reciprocal bars, but no longer practicing, but everyone deserves a fair defense. Absolutely. No question. And I think they're doing a good job with her. I really do. I just don't have the same problem with the not giving her a 9th court-appointed attorney that you do. I think he's been more than fair. It's on her and her behavior that prevented that.
And how long that evidence viewing was.
Of course.
Okay. And then once that's provided to the court, it can be filed, and then the court will cancel the September 3rd hearing. Yes, ma'am.
That is done by the state?
The state will prepare it.
Documents and bring them.
Yes, ma'am. The state will prepare it. All you need to do is just review it and sign it. Okay. All right. Thank you, Mr. J, for providing an alternative solution. Ma'am, I wanted to go back and address your request for the freedom of movement motion that we addressed last week and your desire to use a stun cuff.
Oh.
I understand that a representative from the public defender's office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay. So if you wear a skirt, as explained to you by Officer Barnett, the stun cuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking me was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
As Mr. Barnett or Officer Barnett explained at the last hearing, how the stun cuff is affixed to a person it is on.
Oh my God. See, this is why she doesn't get a 9th lawyer. This is part of it. It's this behavior. No matter what you do for her, no matter how much you acquiesce, no matter how much you bend over backwards for her, she doesn't like it and she finds problems. When she asks you for something, you give it to her, and then she finds problems with it. She complains about it and wants more and more and more. She's not happy with what she's given. Her original motion was she wanted to be completely out of shackles, completely out of handcuffs, and free to walk around the courtroom. They said that ain't going to happen. You can have your hands free. We can give you the shackles, and we can wrap tape around the chain that links the shackle so that it doesn't make any noise when you move. But if you stand up and walk to the lectern up there, then the jury will be able to see you have the shackles. And you don't want them to see that. You don't want them to notice it, because that is presumed prejudicial. If the person's in handcuffs, like, oh my God, they must be guilty, and they must be really, really dangerous. Otherwise, why would they have handcuffs in court? The same for the leg iron. So she wanted this free ranging, free access walk around the court. And the judge said, we can't do that. We got to come to something else. And the prosecution, they put on one of the court bailiffs who said, look, we can do the stun cuffs. And he explained that they're affixed around the Achilles, right around the ankle, right around the Achilles tendon area, and explained how it was operated, exactly the process for putting it on, taking it off, how it's initiated, on what grounds it'll be initiated. She was very, very happy. She's like, oh, great. So I can move my legs. Yes, they won't see any shackle chains. Oh, I can move my arms. Yes, there won't be any handcuffs. There won't be any chain around your waist. The jury will have no way of knowing that you have this shock cuff on your leg. Now she doesn't like it. Now she wants to wear a skirt, knowing that the ankle thing would be visible. So now, oh my gosh, I want to wear a skirt, but if I wear a skirt, they'll see it. So she's trying to get out of it again. She's like, oh, so can't they put it somewhere else? It's like, no, they can't. And that's why they're telling her, look, we gave you what you wanted. You agreed to this. You were very happy a few days ago with this solution that we put the stun cuff on you. It would be covered by your clothing. Now you want to wear a skirt. It'll be visible. The jury will see the shock cuff on your ankle. And now she wants it moved. Now she wants something different. I don't care. At this point, the only reason she wants to wear a skirt is because of that ankle bracelet issue. That's it. Wear a floor-length skirt. Come on. This is just her trying to, again, assert her dominance. All the good stuff I said about the last two hearings, they're done. I'm back to pre pro bono Sarah Boone status. This is infuriating to me. It's the classic example of, give an inch and she wants a mile. Wait, there we go.
On the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need to consider. If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it. And you're making a intelligent, knowing decision that they can see that and that you want to proceed with wearing a skirt. Your other option, if you do not like either of those, is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today, and everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we have our trial case management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access to from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury. And those same restrictions would be placed on the state as well. Now, I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
And by my hearings that we have spoken about the stun cuff, they are televised, correct?
What?
To the best of my knowledge, the media has participated in the majority, if not all, of the hearings that this court has had with you.
Does the court broadcast live, or is it uploaded to the clerk of the court's website?
What is broadcasted live?
My hearings in regards to all of them, basically, but recently the stun cuff. Is there anyone that would know that I'm already wearing it if they could see it or not?
I can't speak to what everybody else knows.
So if I may, please, my options are pants hiding the stun cuff, or a skirt with it being visible, or I am able to sit here at the counsel's table with leg chains on. And no one is able to move except for here at the counsel's tables.
You'll certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
Okay, I just wanted to confirm that those were my options.
Correct.
Those are your
When
options.
do I need to make that decision?
You don't have to make that decision today. It's something that we can address at the trial case management in September. Ms. Click, I see you raising your hand.
All right. Again, this is fair. And he's going over this in excruciating detail, repeatedly advising her, they're going to see this. You know they're going to see this. It's your choice. You wear a skirt, they're going to see it. If you don't want them to see it, don't wear a skirt, because if you wear a skirt, they're going to see. He's doing this basically to shut out a later appeal, saying I was prejudiced because my shock cuff was visible to the jury, and that prejudiced them against me. He's saying you are making he said the magic words, you're making a knowing and informed decision to wear a skirt if you wear a skirt. So shutting off the avenue for appeal if she tries to go down that aisle. And James again says, I disagree. She is posturing just like we would. I really don't think she's smart enough to posture. she's just being obstreperous. She's just being contrary. She's just trying to assert her dominance, I think. And she's trying to take control. She likes to be in control. I don't think she's nearly this clever. To be sheer posturing, and she'll take what she gets because that's how she's performed from day one. She gets you give her this, she wants this. You give her this, she wants this. She just never says, "Oh, thank you very, very much," and lets it rest. No matter the laptop, she got her laptop. I don't have a laptop. I need a laptop. Okay, you got a laptop. She said, "Oh, thank you. Okay, I get it from this hour to this hour. I need more hours," which I actually agree with. But I need more hours. Oh, and now I've got the thumb drive evidence. Oh, now I can't open the evidence. When you say, "Oh, I open up a folder and there's another folder inside. I open up that folder, there's another folder inside." When what the prosecution has done is they've organized this for her. They've put the evidence in folders and subfolders for her convenience, but she's still bitching and moaning about it. So I need the hard copies. But you didn't want the hard copies earlier. Because they weren't safe. You couldn't hide them. You couldn't control them. But now you want them. So you say this, and then she wants this. You give her this, she wants that. She's just being a controlling ghoster type person. That's my opinion. 200 Watt Studio, how you doing? I don't think she likes to be confined. Put in a box and or suitcase, if you will. Yeah, you're right. And James again says, "Oh, I'd go for everyone sitting at council. Minors them too." There's a voice to text error in there somewhere. I'm not sure what that minors them too was meant to be, but that's one thing we talked about previously. This judge is being extraordinarily fair because before the shock cuffs came into play, and also, I mean, it's irrespective of the irrelevant to the shock cuff issue, but they don't want the defendant approaching the witnesses. They don't want the defendant to approach the witness. And of course, the defense and the prosecution both always say, "May I approach?" And then they give the witness a document they want them to review or notes or something like that. The judge says, we can't just have the defendant walking up and getting in the witness's face. So he said the defense is not allowed to approach the witnesses. Any documents the defense has to give to a witness for their review or whatnot will be handed to the court bailiff, and the court bailiff will hand it to the witness, and the prosecution has the same restrictions. The prosecution and the defense, the judge has made it clear, have the same exact restrictions so that there's no appearance whatsoever of any favoritism or prejudice against one party or the other. And he's doing that here as well. If you opt for the leg irons and have to sit at your table, well, the prosecution's going to have to sit down too. This judge is absolutely fair, straight across the board. And 200 Watt Studio, finally, we get to see her long game. Sexy pins. Stop. Don't ever say the word sexy pins in response to Sarah Boone ever again. Thank you very much for that.
Honor, I just wanted to let you, so Ms. Boone is aware fully of what the options are.
If you could, before you get to it, and just announce yourself for the record, please. Yes, ma'am, go ahead.
We have gone through the entire clothing closet as well as our backup for what we have.
I don't know who the hell this woman is or what she's saying. I can't hear a damn word.
As it stands right now, unless we have any donations size that have to match that size, we have 8 pairs of pants, 3 skirts, and 1 dress, and that is every. We do have some shirts, but for in terms of skirts versus pants versus the dress, that is everything we have that would fit in this
Oh yeah, anybody who's had kids knows what she's doing.
So that, if Ms. Boone is making any sort of decision, she understands the limitations in terms of what we have to be able to try.
Okay. Ma'am, did you have the opportunity to hear what Ms. Click said?
I did.
Do you have any questions for her?
If you could please repeat what it is that you all have available, the numbers.
8 years of pants, 3 skirts, 1 dress.
Ma'am, do you have any other questions for Ms. Click regarding the clothing that the public defender is endeavoring to provide for you?
And if I do come to the decision, I can't always have someone externally bring something into me.
Absolutely, you can always have someone provide something in your personal property at the visitation center, which I described across the street from the center.
Yeah, but see, this is the interesting thing. Leah, the empty nester, is just this is what I was pausing to say. Apparently, she is from the public defender's office, and she has no obligation to do this for Sarah. But the public defender's office said we will provide her with non-prison clothing. And you hear, these are the options that are available to her. So the public defender's office, who has just been treated like garbage by Sarah throughout the process, is still willing to provide her clothing. So that's that's good on them. And I did want to make one. I've been here. Let's try that again. I did want to make one statement. I think, to be fair, explained my viewpoint better than I did. Sarah Boone has created the temperature for whatever level of fair she gets by the way she's behaved. This is a reality of her own making. That's what I was trying to say. The amount of fair trial she gets is the amount of fair trial she has created for herself. Everybody is entitled to a fair trial, but at some point you have to take responsibility for whatever prejudicial effects may occur in your trial. At some point, you can't keep bucking the system. You can't keep running off lawyers. You can't keep saying everybody but me is incompetent. You can't keep calling the judge names. You can't keep calling all of your lawyers stupid, incompetent, biased, prejudiced, and expect them to go, all right, here's another one for you to throw into the wood chipper. So that's sort of my viewpoint. Is she has made this, she has every right to a fair trial, and she was afforded every right to a fair trial. And at this point, whatever happens is on her and not on the system. James says, I have such a problem with that sua sponte, by the way. I find it ridiculous. I'm really not sure what part you find to be ridiculous. Plus, she is reaching to find counsel. If she finds counsel, she's entitled to it. The judge has never, ever, ever, ever said she cannot have a lawyer with her. He's just saying we ain't paying for one anymore. And the only thing that the judge did, there was no real sua sponte that I can see. There was no real court making a decision on their own merits. The 8th lawyer asked to be released, and the judge says, okay, I've considered all the options, you're released. So that was the defense lawyer being asked to leave. Sarah asked for a new one, and he denied her request. He didn't just out of the blue wake up one morning, all right, Sarah, you lawyer number 8, you're off the case, and Sarah, you can't have another one. The judge responded to the 8th lawyer's request to withdraw, and the judge responded to her request for lawyer number 9. So there was no real sua sponte thing there. The judge just didn't do anything on his own authority and power. He responded to requests and motions from both sides. So I don't think there's an issue of the judge just going rogue and making decisions on his own, making rulings on his own. I don't see that problem here, but that's just me.
That is not the public defender's office is in no way involved with that. It was put in your property and the corrections with transport of property.
Yes, ma'am. Thank you.
All right. Any other questions for her? All right. Can Ms. Click be excused?
Yes, thank you.
Thank you, ma'am. The next issue that I wanted to address was the review of the digital discovery.
Okay.
Ma'am, Mr. Lane was provided.
Do we get to see
at
the
our
digital
last hearing on
discovery?
the 9th, the hard copies of the discovery, the USB jump drive, which contained the state's digital evidence, and digital transcripts of the depositions of detectives Chelsea Copsell and Scott Lowen. And he was to meet with you on Saturday at 9 o'clock. Did that meeting take place?
Did.
Okay. What was provided to you, if anything, at that meeting?
What he and I did,
What was provided to you? What was given to you by Investigator Lane?
the digital evidence we went over.
Mhm.
And we're still reviewing the discovery, but I don't recall anything physically being handed to me.
Okay, all right. And when you say that you went over the digital evidence, are you referring to the USB drive with the 9 items that were identified in the state's exhibit list?
Yes, I do have that. We have not concluded going through that. We have other meetings tentatively scheduled, which we will be concluding that also in order to meet the deadline for the objections of the 23rd of August.
How many of those 9 items were you able to review with Mr. Lane on Saturday?
Not more than one.
Okay. Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seem to work.
Okay, you did not have any issues opening up any of those files?
I personally myself did not open all of them.
Okay, all right, okay.
It's on our to-do list.
Ma'am, Mr. Lane also took
Dress her up like Annie
possession
Wilkes
of
in
the
Misery.
hard copies.
I'm your number one
Have those
fan.
been provided to you?
We have. They were waiting at the dorm for me upon my return of the last hearing.
Okay, and where are they currently?
They're located at my bunk area.
Okay, and what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
The 2 boxes are at my bunk on the side in between other bunks.
Okay, all right.
So
Are
you've
they
got the
inside
hard
type of
copies.
Bag, or is it just the 2 boxes that are right there?
Just the 2 boxes.
Okay, all right.
The Chewbacca's.
Do you understand
That was childish.
You've told me that you live in a female dormitory with limited privacy. You understand by keeping those boxes there may be a risk as to other persons looking at them.
I don't have any other choice.
Okay, but you understand that risk exists.
Sorry, I didn't turn off my camera
Of
before I took
Okay,
that bite.
you understand that there's a risk that those items could disappear.
I understand.
Okay, all right. And do you understand that it's your request and choice to keep those documents in your possession?
I do, and I'm also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer.
See, this is where she goes back and forth. She originally, the judge says, okay, we've got the discovery here. We've got these boxes. The investigator doesn't want to keep them anymore. Your lawyer doesn't want to keep them anymore. We're going to give you this was a long time ago. I believe it was in June. And she's like, I don't have privacy in my room. You know, I can't be in my cell 24/7 guarding my evidence. You know, there's times I'm not there. They're sitting there. It's not secure in my room. I need it on the digital. I need digital stuff that can be protected. They give her the digital stuff. Well, I need to be able to look at it when I'm not on the computer time. I need my hard copies. And they're like, but you told us this wasn't secure. You told us there was nowhere to put it. Now you want it. She's like, yeah. She's all right, cool. He said that 2 hearings ago. He's all right. Yeah, if you want them, go ahead. All right, we'll give it to you. And now that they're there, he's cutting off her avenue of appealing, saying that, you know, there's things are stolen, things are missing. I was given this, and you know it wasn't protected. He's like, you know, this isn't protected, right? You know, anybody can steal your evidence. It's not secure. And she's like, yep. And I want my thumb drives to be kept in my room as well. So what was originally unsecure and totally insufficient for storing her very, very important evidence, now she wants the hard copies and the digital copies to be stored in her cell, which it goes against exactly what she said a few months ago. It's frustrating.
Also for an extra security measure.
Okay, all right. I see that we'd have Investigator Lane here. Sir, if you could come back.
Now her cell
Madam
is the
Clerk's
most
gonna go
secure
ahead and swear
place
you
in the prison. Great, in the jail. And this is Lang. He is the head of the prison break investigation, her court-appointed investigator.
I do.
Sir, good afternoon. Could you state your name for the record and your affiliation with Prison Break Investigations?
Billy Lane, owner and chief investigator of Prison Break Investigations.
All right, thank you, sir. I did see that your notice that you provided regarding
that's one thing we can agree on. What, if anything, does sound dumb? Thanks, James.
Distribution or providing the discovery. You provided the
no cell,
hard
it's a dorm.
copies and the USB with the digital and the USB
dorm with big doors that lock.
Depositions of the two detectives.
That's correct.
Okay, all right, sir. And when you met with Miss Boone on Saturday, again, I don't want to go into any specifics, but were there any issues accessing any of those USB drives or any of the files?
Not at the progression in which we made through the files.
Okay.
I will be happy to let you know.
All right, very good. But as of right now, there's been no issues as to access from what you've reviewed. Okay, all right. State, do you have any questions for Mr. Lane?
No, Your Honor.
All right, ma'am, do you have any additional questions for Mr. Lane?
In regards to the drives?
Correct, based on what was teed up for hearing today, which was addressing your review of the USB jump drive, which contains the state's digital evidence.
Mr. Lane, are you able to briefly meet with me downstairs after this concludes?
I'm not sure if that's permissible with the policies and procedures. If not, I'm going to try and schedule it.
Okay.
Any other questions for him?
Yoda having an attack.
All right, can he be released?
Yes.
All right, state.
Your Honor,
All right, thank you, sir. Appreciate you. Okay. The next, ma'am, is your letter from August 7th to Captain DiGiovanni, which is the court has had the opportunity to read. I believe that we have a representative from the Orange County Jail who's appearing virtually. If you could please unmute yourself and turn on your camera, whoever it is that may be appearing from the Orange County Jail.
All right, and what she's done is we read this in part one of our two-part series we wrapped up yesterday. She sent a letter to this officer DiGiovanni, who's somebody in the correctional system, basically asking for extended time with the laptop, asking for internet access, asking for telephone access, and these other things. And I guess they're going to hear from just DiGiovanni. She was on vacation until 2 days ago.
I have a Administrative Sergeant De Jesus on the link.
She's got Jesus on the line. She's got the Jesus on the line.
Good afternoon, Judge. This is Captain Gina DiGiovanni with Orange County Corrections. I'm the captain of the Female Detention Center. And yes, I have Administrative Sergeant Stephanie De Jesus with me.
All right, very good.
I will also want to make it clear that I have Orange County Corrections Department Legal Counsel Scott Chevenel on the phone with me.
Okay, very good. If all of you can, if the Captain DiGiovanni and Sergeant De Jesus, if you could please, I only see you, Captain. If Sergeant De Jesus can come into frame, we'll have Madam Clerk swear you in. If you both
that's
could
what
raise
the
your right
Jesus
hands.
looks like. Nobody fucks with the Jesus.
Yes, ma'am. I do.
All right. Could you both state your names for the record for me again?
Administrative Sergeant Stephanie De Jesus. Captain Gina DiGiovanni, Security Operations, Female Detention Center, Phoenix Facility, Genesis Facility.
And can I get appearances for legal counsel for the Department of Corrections, please?
Scott Chevenel, County Attorney's Office, representing the Department of Corrections.
Okay. All right. Very good. Captain, have you had the opportunity to review Ms. Boone's August 7th letter regarding some of the requests that she has in this case?
Yes, and if it's okay with you, Judge, I'd like to address each request one by one. Do you have a copy of the letter?
I do. We can proceed with the 7 different items that she has requested. So if you
Actually, so with number 1, the request to have her review time extended, I can make the extension in the following fashion. We'd still have to collect the laptop at 4 p.m. This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m. That is more than the requested time that she has asked for additional viewing.
Big win for Sarah there. She said, hey, I can only view my stuff from 8 a.m. to 4 p.m. That's not enough time. I want to do stuff after 4 p.m. So she's all right, you got it till 10 p.m., which I think is absolutely the correct response. There's no reason. 4 p.m. was an arbitrary number that the correctional facility just set. So good for that. That's a big win for Sarah, and I think it's absolutely fair and reasonable and appropriate to give her as much time as necessary. I said from the time they wake up till lights out, she should have access to the computer, except for like head counts and meals and things like that. I don't understand the no weekends, like 10 p.m. to 11 p.m. on weekends. I don't get that. I don't know. I don't get why probably because I guess it's just the day off for the correctional facility people. I don't know. Maybe they're understaffed on Friday and Saturday. I don't know. I don't know why, but let's go.
Ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop, that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m. and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes.
All right. Do you have any questions regarding that extension?
I do not.
Okay. Is that acceptable?
Very much.
All right. Moving to the next issue, Captain,
Great.
the USB drive security.
Number 2, USB drives. It's a matter of security. The metal tips, the drive itself can be fashioned into something other than what it's originally intended for.
I was thinking the same thing.
These items are secured in a secure control room and inventoried by our supervisors on every single shift. They're also inventoried and acknowledged being in good working order and repair by my DSTs, the escorting officer, and my supervisors. So at this point, unless directed by legal counsel or consultation with legal counsel, I believe that these drives are secure and managed. This, by the way, is the same way it's managed by other facility captains, that you get a viewing period and then everything gets secured and inventoried.
Reasonable.
Ma'am, do you have any questions with regard to the USB drive request in your letter and the position of corrections regarding it being a matter of security and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
Yeah, because I do agree in principle with the correctional facility. They don't like little bits of metal laying around. So you get a little thumb drive and you garrote someone with your power cable, or you slit their throat with a filed down USB. It seems silly, but it makes sense from a security standpoint. Plus, it just makes sense. What would Jesus do?
Process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why, other than the fact that the assumption could be made that it could be made into something other than a USB drive.
That is the assumption. That's the reason right there, Sarah. It's kind of hard to kill someone with a paper cut. And yes, they are afraid that you might stick the USB drive into something other than a USB drive. Like they're afraid you might stick it into somebody's neck. Yes, that something other than a USB drive would be another human being. That's what they're worried about, you sticking bits of metal into.
Avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know if I could have my hard copies. I'm unclear, other than those reasons why I cannot have those as well.
To the extent you're able to answer that question.
And I would just chip in that, obviously there's safety issues and you can definitely distinguish between, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem, it sounds like to me, is anything that could be a safety hazard is an issue for us.
So, ma'am, do you have any other questions regarding the Corrections Department position with regard to the USB drives?
What was the outcome?
It sounds like unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of storing, inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
And that's due to metal?
That's due to the reasons that were already identified.
Yeah, one of which was
security regarding the drive being fashioned in a way that may affect security, and it continues to ensure that those drives are secured, controlled, inventoried, and in good working order.
Yes, self-safety as well.
Do you have any questions?
Could you please provide the last name of Scott, the legal counselor, please?
I'll spell that, Judge. Shevenell.
Chevenel?
One more time, please.
Shevenell.
That's suspiciously close to Chevenel.
With regard to the third request is to a classroom, Captain DiGiovanni.
We will have good Sarah Boone bingo cards for
that
trial.
classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use of a classroom. What I can offer is
For privacy's sake, she wanted exclusive use of the classroom that's in view of the guards to spend all day and all evening reviewing her evidence. And the alternative was she wanted a pair of headphones. And so they're saying, look, we can't just give her an entire classroom. But here's what we can do for her.
Is if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her, and she can review and conduct case review.
If she wants, I like that. If she's not happy with the way the dorms are, we can put her in an actual cell and lock her in there all day. If that's what she wants, then nobody will bother her. I don't think that's the solution. I bet she's not going to agree to that particular solution. See, they're like, oh, you want privacy? We'll give you privacy. We'll put you in the housing unit. We'll lock you in a cell from 8 a.m. to 11 p.m. except for meals and head counts and whatnot, and give you all the damn privacy you want. How about that, Ms. Boone? Somehow I don't think she's going to agree to that.
She will still have access to a shower. She will still have access to open
basically
day room
Irish
time.
Rover.
She will still have access to phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
They're in solitary.
Ms. Boone?
Captain, is this Lima dorm?
No.
Dorm.
A cell.
Hello. So my only options are being moved to the maximum security dorm or
So it's not just a regular cell, it's a maximum security cell. That's good. Yeah. So she's like, that's my only, I told you, here's the deal. You say you want privacy. Oh, we can give you privacy. We'll put you in a cell in the maximum security wing and lock you up in there all by yourself. We'll give you all the goddamn privacy you want. Yeah, I knew she wouldn't like this.
or my bunk.
K dorm is no longer a maximum security. It's a multi-purpose area with inmates of varying needs being secured and housed there.
Why does Captain
So it is not the maximum dorm any longer.
Degeneres or Giovanni or whatever the hell her name is? Why does she
And I'm
look like
unable to utilize the classroom for an hour or two per day while it's dark the entire.
looks like the Heaven's Gate cult guy?
And if I may ask, other than it being accessed on a rare occasion of the 2 classes that do participate in that classroom, why is it that I'm unable to sit and be viewed by the officers at all times in my dorm comfortably to be able to utilize the phones on a regular basis, the day room on a regular basis?
I know the answer. I think I know the answer. One, we're not going to have an officer that's assigned to Sarah Boone watching duty. We got to watch everybody. We're not just going to have someone stare at you. We don't have staffing to have someone stare at you from 8 a.m. to 10 or 11 p.m. every night. Yeah, that would be my answer.
Is to be able to go outside to recreation, to have just for fresh air.
Yeah.
How is that? I'm not understanding specifically why the reason is it has to be so extreme from going to being locked behind a door 24 hours a day to not being able to just utilize the classroom for an hour or 2 per day.
No, you didn't say an hour or 2 per day. You said the
You
day.
will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours. And instead of having to move items from a housing area into a classroom where the officer may have line of sight, I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security of that classroom while something may potentially occur in the housing unit.
Mm-hmm.
So as a matter of security,
that's
to
an
the
official
rest
way
of
of
the
saying we
inmates
can't watch
in
you.
the housing unit that you are currently assigned, my staff and the facility, I can make the accommodation where I could put you in a single person cell.
Well, she's got the hard copies. She's got the hard copies now. They're right next to her rack there in the
case material
in her dorm room. She's got them now.
And still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
I've been in a situation where I have been behind the closed doors also when I was made PC, when I first got to Orange County Corrections Department. And if it's anything like that, I do not ever want to have that experience again. And to be honest with
Shocking,
you,
isn't it?
Captain, but I do not believe that it would be this simplified. And nonetheless, I'm behind a closed door for 24 hours. Is there anything that I can do?
Nope.
Any kind of research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm, where I do have friends and I do have.
Do you want friends or do you want privacy to work on your case?
In order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours?
Yep, those are your options. Those are your options, Sarah. See, you want privacy. We'll give you maximum privacy. We'll give you 23/7 privacy. You want that? We're happy to give it to you. Otherwise, status quo, baby.
Captain?
Captain.
Judge, I'm going to object to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this broad general question about alternatives.
The objection is sustained.
In regards to number 4, earphones or headphones, I would need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command for guidance in that request.
That's a good one, Elsie. I like that one.
Regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits. So again, I need to refer to legal counsel with legal counsel.
Real quick, Lindsay, she wants headphones. She either wants to be alone in a private room, which they said, hey, we'll give you a maximum security 24/7 private room, or if she can't have the private room, they said no on the classroom. She wants headphones so that other people can't listen to her evidence when she's reviewing videos and things. She doesn't want people hearing the audio, so she wants headphones.
Counsel
Plus
and
it's
my
noisy.
chain of command to get guidance on that. Regarding number 6, a word program, we've not had a pro se inmate, again, myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance.
See, and I see no problem with installing Word on her laptop.
Response.
She should be
Number
allowed
7,
to have Word, I think.
telephone access.
No.
In her statement here,
No.
as you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make all necessary calls. Hold on, I'm turning the page. For my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly, I believe that's diminishes. I don't know what the other word is here. If not all of my opportunities to properly prepare. The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications. Number 8.
This is D. Giovanni. She has a hard time
copies.
reading Sarah's
It seems
handwriting, as do some of us.
Ms. Boone already has access to her hard copies. The concern I have to do now is do some research with legal and my chain of command, because that quantity of paper can potentially become a fire hazard. And we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards, but the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the 2 cases of paper discovery.
All right. Ma'am, do you have any questions regarding Captain Giovanni's and the Orange County Jail's position with regard to the earphones, headphones, internet usage, word processor, telephone, and the concern regarding the hard copies and it being a fire hazard?
I do, and I was also including number 3, the classroom utilization.
I just want to make it clear and in open court that
The strawberry
I
snoring
want
loud.
to have the understanding with everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is or my option to be moved. But I have the ability to make that decision.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security and potentially Miss Boone.
Okay. All right.
Am I able to proceed?
You can.
So for my understanding right now, you need to speak to your legal counselor in regards to the headphones, the internet, the Word program, and the discovery hard copies, which I already have. Is that correct?
And telephone access.
Oh.
You want unfettered telephone access, if I read your
Mm-hmm.
letter correctly.
Ain't gonna happen.
Reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week where I save all of my calls for a particular day. I'm always up for solutions, just whatever it is that I can do in order to progress properly and expeditiously. I'm trying to
And
do so by
futuristically-
having this where I am confused why this was not all
And prequely,
solidified prior to the implementation of the laptop. So I'm
yeah, a lot of them have
very,
tablets, but they're it's like
I'm
audio and
waiting for,
email and things like that, and
whatever it is
video
that I can
files.
do to
And they're
fully
ridiculously
access and
expensive
become
to
a
use
pro
too.
se defendant and inmate. Do you know when, how long the deadline might be for the open-ended items that I would be waiting for?
Judge, this is Scott Shepard. I'll chip in with the legal piece. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above what our typical stance is for pro se inmates, and all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
Is that a position, Counselor, that you're taking today? Because Captain DiGiovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's going to talk to her folks as far as the security end of it, because a lot of those.
And see, the lawyer's right. He's like, he's exactly right. She's not the first special flower pro se we've had here. Everything we've done, we've provided them with what we're required to provide them under the law. She's not getting unfairly treated. In fact, she's getting treated a little better than other pro se litigants are. She doesn't have any grounds to complain. She's got all of her rights protected. That's his legal opinion, and can't disagree with it.
Those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is, she's legally allowed access to the court and all these other things that she wants. And really, and I'll tell you what the case law says. The case law says if she's pro se, she's entitled to get, a paper, a pencil, and some stamps and some envelopes and those types of things. The idea that she wants unfettered access with the phone and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, she's gone through, I think, 8 attorneys in this case, and she had several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Okay, so clearly the correctional Department of Corrections lawyer is not nearly as chill as the judge or the prosecutor in this case. That lawyer's response is the legal version of "bitch, please." He doesn't care.
Ma'am, do you have any other argument with regard to these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding.
No, you're not being penalized. He just said you are being treated like a goddamn princess here. You get a paper, you get pencils, you get stamps and envelopes. You've got hard copies, you've got thumb drives, you've got a laptop, you can hang out with your laptop from 8 a.m. to 10 or 11 p.m. You're getting treated you're not being treated worse. You're being treated infinitely better. Sarah, get it into your head.
In regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that
question. I love this judge. And just the way he phrased that answer was beautiful. She has to say, is the only reason I can't do this because of the lawyer's misunderstanding of my previous 8 lawyers, and that's why I'm being prejudiced? He's like, I'm not going to answer that question. It wasn't like, I'm not going to answer that question, or I'm not going to answer that question. I loved his emphasis. I'm not answering that question. He's like, Sarah, I ain't touching that question with a 10-foot legal pole. I like that. I love that he put the emphasis on I'm not going to answer that question. That was good.
Anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that question.
Being penalized, just the opposite. She's being treated like every other pro se inmate in the
She's being treated
institution.
better.
She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case in the successful outcome that they were hoping for by being provided simply papers and pens.
Sarah, let me tell you something. If you ever happen to actually get an internet connection, or you should ask your investigator to investigate this issue. Have him investigate how many pro se litigants are successful at anything. Have him check that out for you. Yeah, you'll find that laptops versus pencils and paper, stuff like that, doesn't really help your case much, if at all. Just have them do a general search for how many pro se defendants are successful in having their charges dismissed. Sarah might be shocked at how close to 0 the number is.
Ends.
The correctional facility lawyer doesn't even know how to answer. He's just like, I don't know what to do with that question.
Counselor, if you...
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney for one of the participants, sir. If you don't, you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands.
Well, there's a chance.
And requests.
They're simply requests. And I'm not sure who it might be that could answer my question, please, in regards to what prior or present other pro se defendants and inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates that have come through, they're there right now, that have come through the jail, and they get standard treatment. And she wants a lot of things that are over and above that. For instance, again, unfettered phone calls. She wants to keep things in her cell that she can't normally keep, that they wouldn't allow folks to keep. So there's a lot of issues. I mean, that's a wide open question. But, can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that, we could probably find plenty of examples if need be as to what people have received in the past. And it's nothing close to what she's requiring or requesting today.
Okay. Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request as to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously on the record. With regard to your request to hold the USB drives in your own personal lockup, for the reasons identified by counsel Chevenel, it's a matter of security, and the protocol which secures, controls, inventories, and ensures in good working order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain DiGiovanni on the record. However, there is an alternative housing offer that can be provided for you.
Maximum
with
security.
Regard to your request for headphones, that has been rejected and denied by virtue of legal counsel's argument and what is being provided to you. With regard to the internet, word processor, and telephone, again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of an investigator, and JAC provided you $10,000 and $1,000 for travel for your investigator. To the extent as requested for the purposes of internet for locating witnesses and experts, you have a personal private investigator that can utilize, he can do that for you. I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone, based on arguments of counsel for Orange County, I'm unable to accommodate those requests. The jail is unable to accommodate those requests. Those requests will not be provided. With regard to the hard copies, that's going to have to be a matter, if it needs to be addressed, it can be readdressed with regard to the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured housing in the K dormitory?
He's going to get $12,000 out of it. He's okay.
It's basically the Florida Model Jail Standard 7.12. The officer in charge or designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument, and authorized reading materials in reasonable quantities as approved by the officer in charge or designee. Personal items will be kept in an orderly manner. Fire potential is reduced by limiting the amount of personal property in the cells. So it is the sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in
Let her have it. They're inside
letter,
boxes.
if you give me one moment. In number 8, discovery hard copies, she writes the following: as I am presently, I can keep these in the permitted property bag discreetly located at my bunk. I will purge the documents I have now and keep only new discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. I'm willing to see what she's going to purge and send to property. But at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have here, along with the almost 100 or so assigned staff, civilian and certified.
Sarah's gonna start a prison riot. She's gonna lay out all of her discovery and set it on
will
fire.
also say that pro se inmates in the past have been afforded a second fire retardant property bag.
R-worded.
And I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above that, we may have to find an accommodation. And based on the willingness of the letter that Ms. Boone has written, she articulates clearly that she's willing to purge and send to property any paper that's over and above.
Do you have any questions?
And
no, go ahead.
And I can have that second property bag upon her return this evening.
Okay. Ma'am, do you understand the second fire retardant bag that could be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag.
That's why they're going to give you another one.
Times and even had others try to help me put it in the bag. I also did not know that they were fire retardant bags. I have the one already at my bunk, and I'm in the process of trying to figure out what needs to be purged. I also have my second family law case that I'm trying to be able to obtain those copies at my bunk as well, because of the difficulties of receiving and delivering anything to the property department, which is why I came up with the solution of me trying to purge what I can specifically to be specifically removed from the jail completely by a friend who can come and pick that up. I was just waiting for this hearing to happen so I can figure out when to tell her to come to do so.
200 Watt Studios, is Sarah Boone's parents still alive and around? I have no idea. That's a good question. I see that someone. Soul Souffle has said, I read her parents are deceased. I have no idea.
Is that accommodation acceptable?
Of course it won't.
It is.
Oh, surprise.
Returned the second fire retardant bag, property bag, because I didn't want to have anything extra on top of my extra already. And it is not able to be used for anything that I can put in there where I already have everything in the boxes in the one bag already being occupied.
Are you satisfied then with regard to the treatment, for lack of a better word, of the hard copies?
What do you mean by that?
Sure. Are you, the procedure for having them stored and where they're kept is identified today, is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
Judge, may I say something here?
Sure.
Okay, and thank you for allowing me the interruption. The cardboard boxes are not authorized by the fire marshal. The fire retardant bags are. So the documents are going to have to come out of the cardboard box and into the fire retardant bags.
Ms. Boone?
So from this, it seems
I would
that
have to figure that out for the voluminous amount.
yeah, from this, it seems that for maybe for size, I don't know what the size of these fire retardant bags are. I know we have some of you have been through the system and may have an understanding of the size of these fire retardant bags, but I wonder if you couldn't put the cardboard box inside the fire retardant bag. And are we just talking they're tiny little bags, or are we talking they're like duffel bags, or I don't know.
Paperwork that are contained in those two boxes, and there is no way to organize or separate. So it would just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of organizational structure of those 2 fire retardant bags.
Oh, is that what she was talking about when she said I thought she meant she tried to put both boxes inside one bag, which is why I thought they gave her an extra bag so that she could put one box in each bag. But apparently she tried to, from what Island's interpretation of that was the box itself would not fit inside of a bag. All right, I can go with that. Well, see, yeah, that was why I was confused with her phrasing. The boxes won't fit in the bag. So that's why I thought that maybe she was trying to put 2 boxes into a single bag. I know what they're saying now, Island. I was saying I was confused with because I thought, okay, she's trying to put 2 boxes inside one very large fire retardant bag. Perhaps, and that's why I thought that's why they gave her the extra bag, was to put one bag, one box in each bag. But apparently the box itself doesn't fit into a single bag. All right, got it.
My hard copy discovery enclosed in those. If I could please do so.
Mr. Chavanel,
Captain Giovanni, is there any way we can give her an additional bag or so and she can switch it in and out of property or whatever it may be? Can we provide her an additional bag that may help her to separate her documents?
They should put her files in the locked
the
suitcase.
third fire retardant bag, but it's the encroachment into another inmate's area. It's a limited space, but the cardboard box can't remain.
Mm-hmm.
And Judge, if you recall my request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail for this very reason.
And I understand that. And Ms. Boone has continued to request the paper copies. And that's why everything was digitized, so that she would have that access to it. Everything has been digitized, but she has continued to request for those, and we're trying to make that accommodation for her as well. Yes.
And good on the judge. The judge is saying, look, she wants them. She gets them. We got to make this happen somehow. He's telling, Captain Battle Axe here to chill a bit and to try to find a way that will work within the strictures of the fire codes and safety codes and all of these other things. Saying that we're trying to find a way to work here. Don't be so stubborn. I'm sure you have to keep with the fire codes and the safety codes, but let's see what we can come up with here.
Scott, if everything's digitized, why do we have to get the paper?
Because she wants it.
That's up to her if she wants paper or not. That's fine.
All right.
It was never my decision to have anything digitized in the first place, and nonetheless, it's being put on a laptop that is not even fully accessible because some of the programs do not work, which I have not had the time yet to continue to go through everything that are on the USB drives. And
Sarah, you're going to talk yourself out of your USB drives here if you're not careful. Now she never wanted electronic. Yeah, I don't think she ever actually specifically requested electronic things. She was just saying paper isn't secure. I can't be there all the time. Things can happen to it. She implied that she needed something other than paper, but now she's saying, I never asked for these USB drives. I can't use them on the computer. It's all confused. She might talk herself out of the USB drives now. Be careful. Be careful, Sarah. You just might get what you didn't realize you were asking for.
That being not my decision, and nonetheless, and most important to me, they are limited and restricted to particular time periods. When those laptop times are closed for the day, I can therefore pick up the hard copy discovery, be it in a fire retardant bag or in a cardboard box or whatever else it is that I'm able to keep them there at my bunk. I have that as plan B when plan A is closed.
Sarah's in prison. She doesn't need
Judge,
plan B.
I might be able to offer a resolution here.
Okay. What do we?
Was the discovery that Miss Boone received, was it just a stack of papers in the box, or was there any type of manila envelope or filing separation system?
I haven't looked at them. I haven't copied them. They were opened in court back in, I think, June 28th, when we had the hearing where the court found that Ms. Boone had forfeited her right to court-appointed counsel and alternatively have waived that right by virtue of her conduct. I believe the box was open at that time, and There may be manila folders for some of the items, but I can't speak to all of it. I haven't reviewed it. I'm not able to review it.
Would Ms. Boone be able to indicate whether the paper is free-flowing paper or was it bound in some way?
Ms. Cashman had represented that all staples had been removed and all paper clips had been removed. Ms. Boone,
It is a mass amount of paper.
are there dividers? Are there manila folders?
There, I believe, are 2 manila envelopes that have contents inside.
And everything else is just free paper?
As far as my understanding is, yes. I've not been able to fully
Okay,
dive
interesting
into
solution.
the boxes
Provide her with a
quite yet
bunch of
because,
manila folders.
waiting for
She
information
sticks
for
them.
this.
She sticks her
That I
evidence
can
in the
further,
folders. Sticks the folders
explore once I
in
return back to the dorm.
the envelopes in
I
the
can
fire retardant
provide
bag.
some manila folders without any type of clasp or string in order to get the cardboard boxes out of the building.
I understand, and that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified pen and papers I am able to have. My question is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to the amount of paper, is that the definition that you provided, is that
Manila,
for
the
the
capital of
enclosed
Thailand?
housing area, or is this also for general population?
No.
Ma'am, I'm responsible for, based on the Florida Model Jail Standards, to reduce the amount of paper clutter in.
What? I missed something. All right, let me go back. All right.
Without any type of clasp or string in order to get the cardboard boxes out of the building.
I understand, and that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified pen and papers I am able to have. My question is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to the amount of paper, is that the definition that you provided, is that for the enclosed housing area, or is this also for general population?
Ma'am, I'm responsible for, based on the Florida Model Jail Standards, to reduce the amount of paper clutter in all living spaces. It's not specific to just your housing unit.
Why don't you just tell me what I missed? We can't keep going back. You know, I went back as far as I wasn't paying attention. Maybe I just didn't think it was funny. What or what? Someone tell me what I apparently missed. Oh, I heard that. Yeah. That was it? Okay.
Thank you.
Captain Giovanni, does that now, can she switch out and get things out of the property within reason? If there's additional documents
I'm just nonplussed.
Through the request form, if she, we're going to authorize the second fire retardant bag.
Yeah, she's mentioned that earlier, that she hadn't gone through her evidence yet, because she just got the hard copies a couple of days ago. And so yeah, she mentioned that at the beginning, that she hadn't gone through her evidence yet.
We're going to offer some manila envelopes without a metal clasp or string so that she could get everything into the fire retardant bags. And then we're going to remove the cardboard boxes, which are what becomes or is the fire risk, because it is not authorized or recognized as a, fire retardant item based on the fire marshal. The only thing that they consider fire retardant is the bag. And again, I will provide that. And then anything in excess, she could send to the property room. Well, and then upon her need for it, she could write a request to the property room, and the property room will bring it over. But she'll have to swap it out. I'm amenable to her keeping her documentation. I'm not looking to take anything away from her, but it has to be in accordance with, fire marshal and policy.
I understand. And I would be happy to comply with the extra bag and the manila envelopes for separators in regards to that.
So, ma'am, if the jail was to provide you those manila folders for the hard copies and a third fire retardant bag, is that acceptable?
It is, if I do conclude that I need anything additional in order for them to be able to be held together in regards to some type of rubber band or some elastic, something to be able to bind the paperwork together. Is that a possibility?
I didn't hear the question.
You may have to speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed, to have a type of rubber band or some kind of elastic in order to bind?
No.
And I know, Captain, that you are aware the courtroom is not in regards to the property bags that you all do supply. There's no rigidity to them whatsoever. It is just a floppy bag.
That's why they're called bags,
when you
not
pick
boxes,
it up,
not
everything
suitcases.
goes in the middle. So there's no type of
That's
there's
what
no
the
way
manila
of actually
envelope
being
would do.
able to make sure that one pile stays in the one pile and so on and so forth.
Put them in a manila
Do you have
envelope.
any
It'll
suggestions
solve it.
other than manila folders that I might be able to utilize in order to keep those together?
No, manila
The
folders.
purpose of the manila envelopes is that you would put the paper in
See,
the
she's
manila.
talking folders where the papers can fall out. Heaven's Gate lady captain up here, she's saying manila envelopes. The envelopes, you put them in the envelopes, they don't fall out. See, Sarah's not paying attention. There's a difference between a folder and an envelope. You put them in the envelope, it keeps the piles separate, and it keeps them in the deal. There cannot be an accordion file fire hazard. It needs to be in a fire retardant bag. And so they're saying that the things that are in her box now, she's got the 2 cardboard boxes. They've got to get rid of the cardboard boxes, and they're trying to find a way to get rid of the cardboard boxes, but allow her to keep her papers. So the prison lady is suggesting she puts them all in several manila envelopes. Sarah keeps talking about manila folders.
Envelope, and that manila envelope keeps paper in order.
Okay, so they're envelopes, not folders.
Yes.
Correct.
Jesus.
Thank you.
Ma'am, is that acceptable to you? And is there anything else we need to address with regard to the hard copies?
Not in regards to the hard copies, no.
Okay. All right.
Rocco says Manila is Manila, envelopes folder the Philippines. Well, that's actually why they're called Manila envelopes. How's that for just a little sidebar here? They're actually called Manila because they were originally produced with Manila fibers from Manila hemp fibers, and the Manila hemp was named after Manila, the capital of the Philippines. So that's why they're called Manila folders. They're made from Manila hemp. Manila hemp was named after Manila, the capital of the Philippines.
Is
Fun
there
fact.
anything else, ma'am, that we need
Things
to
that I
address
have
today,
questions
Ms.
about
Boone?
that I found answers to.
Yes, please, if I may.
I'm awesome at Trivial Pursuit because my brain is so full of useless, shitty information that has no practical value. Whereas important stuff, I can't remember to save my life.
Conclude with the remaining amount of questions that I have in regards to my requests.
Sure.
Is it Mr. Shebamel?
Yes.
Could you please provide me with the protocol or policy that you all have a guideline for me to follow, please, in regards to what previous pro se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
We'll have to check on that. You asked for, are you making a public records request?
I'm sorry?
Are you making a public records request?
I'm unclear of your question. I was just asking if Orange County Corrections Department had any type of guideline that you are accusing me of going above and beyond, other than the pen and paper. So I didn't know if you had a policy or process in, if you have a pro se packet, like JAC has a pro se packet. Does Orange County provide something like that?
You'd have to ask the jail that question. I don't know. I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as to what the law is, but I'll certainly advise the jail as to what the legal standard is.
This guy hates her.
Captain, I would be
The correctional facility lawyer
does
not like her.
you or Sergeant DeJesus.
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop and the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Shabamel, you repeated that I have access to the court. Could you please define to me what your access to the court is for me?
What?
Yeah, I'm going to object. I'm not a witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know I've entertained a few, but I'm really not required to answer any.
Ma'am, he's not in a position to answer those questions.
Could you please answer who might be able to?
No.
Because I am in desperate need to view the case docket.
That's why you should
which
have a lawyer.
requires
Oh,
internet, and I am still waiting for any documents that you have mailed to me. I am unprepared, it seems, every single time now sitting here at the counselor's table with not the same information and opportunity and advantage as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those more expeditiously and in
How about
a
pay attention in
timely
court?
fashion so I can be prepared in order to properly defend myself in apparently more than one way for every time that I'm here in the courtroom and something new is presented to me as a surprise. So I'm just trying to avoid those.
Items will continue to be mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify, my understanding is the only way that I can receive anything is through United States Postal Service.
I'm not going to answer that question because that would be me potentially providing you legal advice. But what I can tell you is that items will still continue to be mailed to you as required by those rules.
If I may please just make sure that everyone is aware that I cannot be properly prepared, as you can see now.
we are more than aware because you won't shut up about it.
Aware and understands that.
Ma'am, for the reasons that we've discussed previously, I understand that. You're entitled to that opinion as to your pro se representation of yourself. Anything else that we need to address today? Ma'am.
Yes, I have a motion that I would like to submit, please.
Okay.
Oh, God.
Is there anything else that the jail needs to participate in with regard to this hearing?
Captain, would I be following up with you or who would I be speaking to when I return to the dorm?
In regards to what?
I'm wondering in regards to the guideline and when and how the discovery hard copies, will the property bags be waiting for me when I return?
I will take care of that with my supervisors that are on shift.
Yes.
We will need the cardboard box so that we can dispose of that properly.
Yes, ma'am. And if I may, do you know why it was not approved prior when a supervisor was the one who delivered it to me?
I have no information about even the amount of hard copies. I didn't even know that that came into the jail because my conversation has always been that everything would be digitized and that we would have no hard copies so I could be in compliance with the Florida Model Jail Standards, Orange County Fire Marshal, and our policy.
I like that answer. So if I'm not allowed to have these, then why do I have them? Why? Hey, I didn't even know that. I didn't know until now. Now I know. So now you can't have them. Now we got to come to this other alternative arrangement here. I like that. Hey, look, I'm the captain. I just found out about this. So now we've got to do something about it because I know about it.
The procedures regarding excess amount of paper.
Yes, ma'am, I understand. Thank you very much for your time. And Sergeant DeJesus and Mr. Shabamel.
Okay, are they free to leave?
Yes, thank you.
State. All right. Thank you all very much.
To compare.
Ma'am, you made reference to another motion or something else that you had.
All right, what do we got? Looks like we got about 8 minutes left. So this is not going to be a big motion, or maybe it will be a big motion. They'll say, we'll worry about it at the next hearing. Oh God, let's hear what her new motion is. I like how the prosecution hasn't submitted a single motion yet. They're just like, yeah, I think we got enough to convict her. we don't need no stinking motions. Oh no.
Yes, I have a motion.
Okay, if you can hand to the deputy behind you. Actually, deputy, can you hand it to the state? State, you can take a look at it and then I will.
How much shit do you think the counsel was talking as soon as the call hung up? Oh, he was talking all the shit as soon as the call was hung up. They're still talking all the shit.
Thank you, sir. All right, ma'am, give me a moment to take a look at this.
Okay, so the prosecution didn't really care about it. Yeah, see, I'm conflicted. I don't know when it switched for me, when it shifted from, I used to hate having things on digital copies and I would prefer to have them on paper, but at some point it shifted a few years ago to where now most of the stuff I do, I think probably when I got 2 large monitors for the computer in my office and I could like have multiple documents open at the same time and see them all. But there's times when I like the hard copies. Like if I got to make notes, I don't want to have to make digital notes about a digital thing. I like to write in margins and do things and be able to quickly flip through stuff rather than page. There's just sometimes when it's good to have certain documents, from my perspective, in a hard copy rather than digital copy. So it's just weird. It is a sweet deal to have the laptop, but sometimes paper is more convenient. Yeah, see, Hayden's a scribbler. Oh, Hayden, you missed one. You missed a very important thing. Aussie Overlord, everybody. Law, news, and laughter with Aussie Overlord. Make sure you subscribe to Aussie. But you missed something. She was talking about she just got some new mail from Australia. She got some new email about her case from Australia. Anything you want to talk about or confess to, Hayden? Now's your chance to do it. Anything, Hayden? Yep. South Korea is off the hook. South Korea is off the hook. It's she's on Australia now, so yeah. I'm apparently off the hook now, and it's all in Australia. Oh, come on, Judge.
The court has been provided a motion for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of the defense.
She wants a shrink expert.
State, I don't think we can have a hearing on this without JICS.
State takes no position. We don't have anything to do with this.
Okay. Ma'am, I can't have a hearing on this today. I will have to coordinate a hearing with regard with JACS to have this heard because this is something that involves them.
Correct.
And they haven't even had the opportunity to review it yet.
And they are copied on that as well.
I do see that, but you're hand filing it with me right now.
Correct. Thank you.
So the court will file this in the court file and we'll coordinate a hearing as soon as practical with regard to
She wants a shrink. She wants some money to hire a shrink, a neuropsychologist, like Charles Xavier or someone like that. She wants to hire a neuropsychologist. She wants money from the state. She's filed her motion to get money from the state to do that. Prosecution's like, not my deal. That's the jail people. That's the justice people. That's their deal. I don't give a shit one way or the other. And so now they need to bring the JAC people in to have a hearing about it. So that's what this is all about. I can't talk about it today with JAC. They're the ones that make the determination on whether or not to give money, and then I rule how I see fit. But we need them on it, so it'll be between you and JAC, and I'll schedule something.
Motion, and it'll be heard before the end of this week.
Oh,
anything else, ma'am?
Holy cow! Now, Sarah. See, she was like, "Oh, even though the judge said we're going to have a hearing on your motion to move freely about the court and your motion about the evidence, even though he told her we're going to have a hearing on the 14th, she said, I didn't get anything in the mail. I wasn't prepared." He said, "You said it orally, and I orally told you we're having a hearing on this day." So, Sarah, he's just told you. You're making a motion. You've made the motion. It's been orally here in court and in writing. The judge is going to mail you through the U.S. Postal Service a notice of your hearing date for your motion to get money for a shrink. That is going to arrive after the hearing is over, most likely. But you're being told right now, Sarah, that there is going to be a hearing on your motion for shrink money before the end of this week, which is like 2 days from now. So start preparing now. Start preparing now, Sarah. You've been told you can't use that same. It didn't work for you the first time, and it sure as hell ain't going to work for you the second time. Start preparing now, because you got 2 days.
Just to confirm, please, for the next deadline for my responsibility to meet would be the August 23rd for the objections to the state's USB drive that they provided.
As identified in the court's order, that is the deadline. The only other deadline, ma'am, is the September 3rd deadline for the viewing of the state's physical evidence, which sounds like that's something that may take place prior to that deadline. As you may recall, you will have 14 days after that evidence viewing to tender any of your objections in writing to the court.
Sarah,
14 days thereafter, and that will be extended for good cause shown. Anything else, State?
Nothing, State.
Ma'am, anything else?
I need to put that into a.
All right. We'll return Ms. Boone back to the custody of the Orange County Jail.
That's got to be worked into the
we'll
intro.
coordinate the hearing appropriately. Thank you all very much.
Oh, Susan.
Forgive me. In order possibly.
Susan, we're on this. That's telepathy right there, man. That's telepathy right there, Susan M. There you go. See, I am one with my viewers. We're all on the same wavelength.
For a solution for me to know about the hearing, especially for the one regarding the JAC, is it possible for you please to relay it to Mr. Lane and he can tell me sooner than the mail?
I can certainly do that.
Going forward,
Live
so
in Pigeon
I would have
Heel.
some opportunity
Sit, Ubu, sit.
quicker than waiting for the mail.
I can certainly advise him of that, or my office can. Sure. Okay, I understand. All right, just so for recap purposes, with regard to The motions to intervene is first addressed this afternoon. The court orders that the defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Publishing Co. versus Lewis, 426 Southern 2nd, 1 at pinpoint 8 by the Florida Supreme Court 1982. As such, the defendant's requested closure of the state's physical evidence viewing with the state and defendant set for September 3, 2024 at 9 a.m. is denied. With regard to the other items that were discussed today, defendant and state agreed to an alternative arrangement as placed on the record on August 14, 2024 regarding the viewing of the state's physical evidence as tendered in open court on August 9, 2024. The state shall prepare for all parties to execute a notice reflecting when the evidence viewing took place and the length of time that the evidence viewing took place. The state shall file with the court the executed notice after the viewing of the state's physical evidence takes place. Defendant's request regarding extending the laptop time has been agreed to by Orange County. The times have been extended as follows: Sunday through Thursday, 8 p.m. to 10 p.m., and Friday and Saturday, 8 p.m. to 11 p.m. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department Security Operations, which was previously provided to Ms. Boone and read to Ms. Boone. Defendant's request regarding the discovery that was provided to the court on June 28, 2024, and keeping that discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14, 2024, and the balance of defendant's requests cannot be accommodated for the reasons placed on the record on August 14, 2024. Ms. Boone, you'll be given a hard copy or hand-delivered a copy of these orders momentarily.
Thank you.
All right. Anything else? Anything else, ma'am?
No, Your Honor.
All right. Thank you very much.
Thank you.
All right. Whoo, there we are. The end of a hearing. 3 hours. The hour and it took us like double the amount of time because I talk too much. But I'm glad we're all here. Let's see what we got going on over here on the I think I've got everything. Yep, we've got all the super chats and other things here. Silent PS says was the Ubu from Family Ties. I can't. Ubu Productions. I think they did Family Ties too. But like at the end of all of the Ubu Productions, they have like the black Labradors like sit Ubu sit. I believe Family Ties was part of Ubu Productions. But yes. All right, let's see. We didn't do any midstream grifting here, so. 3 hours ago, we started 2 hours ago and an hour ago. I should have mentioned that we've got a lot of people here right now. We got 311 people here, 231 likes. Everybody reach down there and smack that like button. Strawberry stretch. There we go. Reach down there and smack that like button and please subscribe to the channel if you haven't already done so. And if you have, just double check to please make sure you're done. Let's get those numbers up. YouTube insists on removing subscribers frequently. So let's buck the trend. And last chance at the like and subscribe poll here. Should the media be allowed at Sarah's evidentiary hearing? Well, now it's kind of a moot point, but 7% of you said no, it's too prejudicial to her. 11% said yes, no, maybe, I don't know. And 27% of you said yes, because we want to see. And 55% of you said yes, of course, it's a public hearing. Thank you very much for that. I don't know who is live right now, but let's see if we can find somewhere to send you. And I've decided that I need to work, and I don't know why I didn't think about it until Susan and Em and I had a little moment of telepathy. I don't know why I didn't think about putting Starship Sarah into an introduction. I've got to at least put it on a button. That's what I need. Well, we need to incorporate the Starship song Sarah into the introduction somehow. All right, let's see. Go into the studio here and find out who, if anyone, is streaming live now that we would want to go to. Let's see, YouTube Studio. Island says, I checked, still subscribed. You're stuck with me. I wouldn't have it any other way, Island. Thank you so much. Content. Today's hearing live. Customization. Redirect. Let's redirect to Looks like MG Law is streaming this. Looks like he is showing the Sarah Boone trial. So, what the hell? Let's see. Let's give you some more Sarah Boone and compare and contrast. Let's see what MG Law has to say about this, shall we? I think he's going through this exact hearing right now over on his channel. Wait, what did Livid Pigeon say? Can you send us to the nearest bar? Yeah, no, that was Hayden says it's in my living room. Actually, my nearest bar is kind of like right here. 1, 2, 3, 4. Yeah, like 6 bottles here within arm's reach. But that's for research purposes. It's 3:39 p.m. here. It's much too early for that. All right, let's get going on over to MG Law. Tell him hi. Tell him Legal Vices sent you, chat. I just want to let you know that we will be here in 6 more hours, 6 hours and 20 minutes from now. We will be doing our Thursday retro trial, Florida versus Donald Hartung. Part 11, we're winding down this case. And don't worry if you part 12, I think. Geez. Anyway, it's part 11 or 12. We're nearing the end. If you haven't caught the previous parts, it doesn't matter. Just come and hang out with us. We have fun. It's a fairly easy trial to catch up on. We have a little bit of fun while we do that. That will be 6 hours and 20 minutes from now. And Friday, still up in the air whether we're going to have an unexplained stream with a Bigfoot hunter, ghost hunter medium, or whether it's going to be me playing Phoenix Wright, Ace Attorney on stream. And then all of next week, Megan Fox and I will be breaking a new and interesting case involving some very familiar people. We're working out the logistics of how to do that, but please stand by for next week. There's going to be a lot of fun. And sometime during the weekend, we will be having a members only stream. And a week from Friday will be the August F It Friday stream, a huge panel of guests, a much more limited alcohol consumption than we have. I'm stealing Hayden and Nick Staro's. I'm calling it the F It Friday. What was I going to call the F It Friday Fickle Ferris Wheel of Fate? I need to keep the alliteration. The F It Friday Fickle Ferris Wheel of Fate. We'll have about 20 different selections. Every $100 that comes in, we'll randomly spin the wheel and either get a reward, a punishment, or something in between. We're going to have fun. I can't do the straight shots anymore. It's the diminishing returns. It's no longer fun and enjoyable, but I guarantee at least half of those selections will be alcohol related. So there'll still be the fun. It just won't be completely off the rails because I want to enjoy my F It Fridays too. So stay tuned for that next Friday. And until then, let's go say hi to MG Law. See you in about 6 hours and 18 minutes from now. Take care, everybody. Thanks for being here. Love you all and enjoy the rest of your evening, night, whatever it is. See ya. And where's my outro? Where's my outro? I've lost my outro. There it is. Goodbye, everybody.